Hello, Jacob. Can you talk? Are you able to talk where you are, or you just type?
Yes, I'm able to talk where I am. Good morning.
Okay.
Yes,
So
Freetown is good.
if I if I
Freetown is
if I
okay.
understand you well, Freetown, good morning means you are in Sierra Leone, right?
Yes, I'm in Sierra Leone. Thank you.
Sierra Leone. Okay, so you are in Sierra Leone.
Yes.
Can you hear me?
Yes,
Okay,
I can hear
great.
you. Yes, I am in
So
Sierra Leone.
how is the practice there? How is the ADR practice in Sierra Leone?
The ADR practice it's picking up in Sierra Leone. Given the fact that we recently just had the Arbitration Act itself. So the practice of arbitration and mediation is there's an uptick as far as I'm aware, especially on arbitration, and there's a lot of mediation going on, even though not in a structured mediation way in its strict sense. But there is an uptake generally on ADR practice. Hello.
Okay, thank you
Okay.
for the insight that you shared. One.
Thank you.
Thank you.
Okay. Yes. Good morning, good afternoon, good evening, depending on where you are joining us from. We are happy to welcome all of you once again to day 2 of our conference. At this note, let me call upon our host, Sewesi Yaji Ondo from Nigeria. Sewesi, if you are ready, please take over. Thank you.
Okay, thank you so much, Mr. Isaac. Good morning, good afternoon, good evening, everyone. I'd like to welcome each and every one of you, distinguished participants, esteemed speakers, panelists, and moderators, to day 2 of the African ADR Conference 2026. I remain your host, Sewesi Yaji Aondo. And on behalf of the Executive Council of the Africa Center for Collaborative Dispute Resolution and the Association of Conflict, Peace, and Security Experts in Africa, it is our honor to have you join us from different parts of Africa and across the globe. So once again, I say welcome to day 2 of the conference. In Africa, we say Akwaba, we say No, Ekabo, Sanudazua, Msunedavan, Karibuni, and Bienvenue. So welcome to each and every one of you, and we're glad to have you on board today. So before we proceed, I'd like us to look at a few ground rules again. So ensure that your mics remain muted unless you are invited to speak. Ensure that for questions, we'll be receiving questions in the chat. So you can feel free to drop your questions in the chat as we go through the program today. And also ensure that you are logged in with your full name and country where you are joining us from, if possible, to allow us network with each other. And then it's an online event as well, so there might be a bit of network interruptions here and there. If that occurs and we lost communication, please notify us, and we'll ensure that we rectify that. So having said that, we'll just proceed to commence the program. Yesterday, we explored critical issues surrounding ADR practice across Africa, institutional strengthening, capacity building, and the important role of women in ADR and peace building. And today, our discussions will build on the foundations that were laid yesterday, and will focus on cross-border, continental, commercial disputes, and technology and online dispute resolution, investment disputes, in economic growth, traditional dispute resolution mechanisms, and then we'll finally chart the future roadmap for ADR development in Africa. So to formally commence with the program, I would like to invite Mr. Jacob Kendall to take us on the opening prayer. So Mr. Jacob, you can unmute and lead the opening prayer. Thank you.
Yes, thank you very much. Let us pray. Father, in the name of Jesus, we thank you for today. We thank you for this opportunity for all of us as Africans to come together for this community. Father, we appreciate you for giving us this opportunity to talk and identify issues concerning us resolving dispute. In the name of Jesus, we pray that this entire session, Father, it will be directed and chaired by you in the mighty name of Jesus. We thank you, Lord, because, Lord, it will be an open place where we can talk and we can learn from each other. We give you all the glory. We give you the praise in Jesus' mighty name. Amen.
Amen.
Thank you. Thank you so much, Mr. Jacob, and amen to your prayers. So immediately after the opening prayer, what we'll have is the African Union anthem.
Let us all unite and celebrate together the victories won for our liberation. Let us dedicate ourselves to rise together to defend our liberty and unity. All sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa the tree of life. Let us all unite and sleep together to uphold the bonds that frame our destiny. Let us dedicate ourselves to fight together for lasting peace and justice on earth. All sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa the tree of life. Let us all unite and join together to give the best we have to Africa, the cradle of mankind, the font of culture, our pride and hope and break of dawn. Oh, of the sun and flesh of the sky. Let us make Africa the tree of life.
Thank you, thank you. So welcome once again, everyone. At this moment, we'll invite the President and founder of the African Center for Collaborative Dispute Resolution and the Association of Conflict, Peace and Security Experts in Africa to give us brief opening remarks and recap of all that we did yesterday. Thank you. So welcome, Mr. Isaac. You have the floor, sir.
Thank you, Soese, and good morning, good afternoon, and good evening, depending on where you are joining us from. Thank you all for making time to join us for day 2, and particularly our distinguished chairperson for today, Professor Olagunju. I have seen our chairperson for the conference, Professor Emilia, also online. Professor Emilia, thank you for once again joining us, and all the speakers. I've seen Tina, I've seen other people joining. Thank you so much for joining us. We appreciate your support. We couldn't have paid you the amount that you deserve if we have to be charged for joining us, and thank you for giving us opportunity to serve Africa in this direction and at this particular point in time, as we are still talking about the need to trade among ourselves, the need to do more between the African continent. And we say thank you. And we want to welcome everyone, all the participants, to the day 2 of the conference, and to just a few recap of what we did. Yesterday was a good start, where we received a good keynote. And we started from Professor Emilia, where she gave us a good perspective and also accepted to chair the conference, and we received a good keynote from Foloke. Thank you so much for that insightful keynote address. We received a lot of panel discussion, insight from various countries, Kenya, Ghana, Nigeria, and other countries that we shared a perspective from. Also look at women in ADR, their role, and some of the distinguished women also came here to share their perspective and how they got into the ADR practice. Today, we are taking the discussion forward, where we're going to have a speaker session, which our chairperson for day 1 will take us through positioning Africa to handle cross-border commercial disputes with AfCFTA in focus. Then we also have a speaker session 2 by Ms. Faith, who will take us through technology, online dispute solution, and future of ADR in Africa. Then we're going to have another panel discussion where we are going to look at ADR and investment dispute under AfCFTA, which will be moderated by Tina, and also with panelists Jude, Amel, and Joseph George. Then we also look forward to have panel session 2, ADR as a tool for economic growth, peace, and sustainable development in Africa, which is going to be moderated by myself and Sewese. We expect to have Rebecca or replaced by Nicolina, and we have Bingozi Miriam again, and Dr. Deepika Sani from India as well joining us. Then after that, we're also going to engage in a conversation again, where we're going to look at traditional African dispute resolution mechanisms and their relevance in today's dispute resolution, so that we are not leaving what we have as Africans behind. Then we'll come to final plenary session, where you as the participant, the speakers, the hosts, everyone, we're going to engage you on the future of ADR in Africa, developing the continental roadmap. That will be all speakers and all the people that are on board for us to engage in a dialogue and to make sure that we have something to work with and we develop a pathway. It is my vision that, as I mentioned yesterday, that not only that we are meeting on online, although technology has made it possible for us to sit in our homes, in our offices and meet, but I'm looking forward to meeting all of you physically as well. So if you join me, or if you agree with me, as AfCCoDR and ACPSEA, we want to declare the third week of every June, Africa ADR week, where we'll have various engagement and even try to have a physical conferences and meetings. So if you agree with me, from every year, third week of June, we want to celebrate Africa ADR week, and that is what we want to be going from here, so that we can still continue talking, continue developing ourselves, and continue to shape the way we want dispute to be resolved in Africa. It is our dispute, and we must dictate where it must be resolved, how it must be resolved, and the kind of people to resolve them for us. On that note, let me say a big welcome to all of you, and thank you all for joining us for day 2. Thank you, Sewisi.
Thank you so much, Mr. Isaac Asare, for those wonderful remarks. So welcome once again to everyone on the call today. Please feel free to use the chat. Let's know where you're joining from. Let's know your name so that we can network and interact with one another. So to proceed formally into today's session, we are beginning with a very important conversation today on positioning Africa to handle cross-border commercial disputes with Africa in focus. So our speaker today doubles as the chairperson for day 2, and is no other than Professor Olajide Olagunjo. Professor Olajide Olagunjo is the president and professor of conflict resolution at Jesus College, Maryland, USA, and he has taught public resolution for over 3 decades. He created 2 conflict resolution theories, the 10-step mediation and the 7 secrets of effective conflict resolution. He's the author of several publications in about 30 languages in conflict resolution, anthropology, and peace studies. His current research is the intersection of policy law, poverty, development, and peace and violence. He teaches conflict resolution in English and French in universities across the Atlantic in both civil and common law jurisdictions. So ladies and gentlemen, join me to welcome our speaker for this session and our chairperson in person of Professor Olajide Olagunjo.
Thank you so much.
You are welcome, sir.
Thank you. Professor Emilia, welcome, and thank you for opening us up so strongly yesterday. That was very, very nice. That was very, really focused and amazing. And I don't know if you were there at the end, but we built on that well-established start to begin to see that we have a responsibility to ensure that while not wanting to bring other people's dispute to resolve in Africa, we must own the dispute resolution processes of our own disputes. So it's very critical. And then there was a call for us to be more responsive towards ensuring we do that, more conscious, more sensitive to the need for us to own our own. And as I listened to the Continental anthem today, I realized that it's still part of the liberation process. And so as dispute resolution expert, this is our contribution. What I did was write a paper on what we are discussing. I hope people can see my, what's it called, my screen. Yes, I want to see if I can enlarge it. Okay. So that's why I wrote a paper, and I'm going to please ask you to oblige me to let us go through it together. Why I think it's important for us to own this paper, at least in terms of adoption for discussion, is that what we are discussing in this conference is so critical and important and timely. And everyone that has made the sacrifice to be here is very important to taking us forward. And so the topic is positioning Africa to handle cross-border commercial disputes. subtitled Rethinking ADR under the AfCFTA framework. And the summary of what I want to say is that the African, 1 second, I want to remove something blocking. Okay, the African Continental Free Trade Area, AfCFTA, represents a transformative initiative aimed at fostering economic integration and expanding intra-African trade. However, its long-term success depends on not only on market access and regulatory harmonization, but on the effectiveness of dispute resolution systems capable of addressing cross-border commercial conflicts. This paper therefore argues that the current state-centric dispute settlement mechanism under AfCFTA is structurally insufficient for resolving disputes between private sectors. Drawing on my relational theory of conflict, which conceptualizes conflict as unmet needs within a relationship, the paper advances a process-based approach to dispute resolution through the Pentagon framework. This framework provides a structured methodology for transforming disputes through stages of engagement, understanding, and resolution. So through doctrinal analysis and so on, including looking at OADA, and as well as African arbitration hubs and global enforcement mechanisms such as the Singapore Convention, the paper identifies critical gaps in capacity recognition and institutional trust. It argues that the effective dispute resolution requires a shift toward an integrated Africa-first ADR structure grounded in accessibility, legal harmonization, professional competence, and trust as foundational infrastructure. And then I go on to conclude that building such a system is essential not only for resolving disputes, but for sustaining economic integration under AfCFTA and positioning Africa as an effective contributor to global dispute resolution practice. Now, I then begin by asking the question, which I've hinted in the summary I just gave. Trade without dispute resolution? AfCFTA promises to transform Africa into a single market of unprecedented scale. It represents not merely an economic agreement, but a structural reimagining of intra-Africa trade. However, a fundamental question underlies this ambition. Who will resolve Africa's cross-border commercial disputes and how? And I think that's the core of this conference. Now, as trade expands, disputes are not accidental. They are inevitable and structurally embedded. The effectiveness of AfCFTA, therefore, depends not only on tariff reduction and market access, but on the existence of credible, accessible, and efficient dispute resolution mechanisms. The AfCFTA Dispute Settlement Mechanism, DSM, modeled on the World Trade Organization framework, provides for consultations, mediation, panels, and appellate review. Yet, it is fundamentally state-centric, designed for disputes between state parties. In contrast, most disputes arising under AfCFTA will occur between private commercial actors. This mismatch between public law structure and private commercial reality creates a critical institutional gap. So my paper argues that addressing this gap requires not merely institutional reform, but a reconceptualization of dispute resolution itself. Now, the African ADR landscape between tradition and transplant. indigenous foundations. Alternative dispute resolution ADR in Africa is not an imported concept. It is deeply rooted in indigenous traditions that have emphasized reconciliation, consensus building, and the restoration of relationships. These traditions reflect a relational approach to conflict in which the objective is not merely to determine rights or assign liability, but to repair the social fabric within which disputes arise. As Marer observes, African systems of dispute resolution have historically prioritized social harmony over adversarial victory, placing emphasis on dialogue, mutual understanding, and collective resolution. Now, contemporary development. Despite these strong indigenous foundations, modern ADR frameworks across Africa often reflect transplanted legal models. Arbitration laws and institutional structures are frequently patterned on international standards, particularly those derived from Western legal systems. Nonetheless, there has been significant progress in the development of ADR across the continent. Arbitration institutions have expanded, mediation frameworks are emerging, and there is increasing alignment with international best practices. Yet, this progress remains uneven. Significant constraints continue to limit the effectiveness of ADR systems, including weak enforcement mechanisms, limited institutional capacity, and a shortage of trained practitioners. These challenges highlight a persistent tension between formal institutional development and practical functionality. The cross-border challenge. The challenges of ADR in Africa are further compounded in the context of cross-border disputes. Such disputes introduce additional layers of complexity, including jurisdictional fragmentation, legal diversity, and uncertainty in enforcement across national boundaries. Now, in response to these challenges, arbitration has emerged as the dominant mechanism for resolving cross-border commercial disputes. Its perceived neutrality and enforceability make it attractive to parties operating across jurisdictions. However, arbitration is often expensive, procedurally complex, and in many cases inaccessible to small and medium-sized enterprises. Mediation offers a more relational and flexible alternative. It enables parties to preserve commercial relationships and address underlying issues more directly. However, despite these advantages, mediation remains underutilized, largely due to structural limitations, including weak institutional support and enforcement challenges. The after dispute settlement problem. The after dispute settlement mechanism, DSM, is designed to ensure predictability, transparency, and rule-based resolution of disputes between state parties. While this provides an important foundation for the governance of trade relations, the system is structurally constrained by its state-centric design. Only state parties have standing under the DSM, which limits its applicability to disputes between governments. This design produces what this paper identifies as the public-private dispute gap. While states litigate issues relating to treaty obligations, most disputes arising from cross-border trade occur between private commercial actors, particularly in relation to contracts. As a result, private actors must rely on alternative mechanisms, most notably arbitration, to resolve disputes. Mediation remains marginal, and Africa risks continuing to outsource dispute resolutions to external jurisdictions rather than developing internal capacity. Now, rethinking conflict. At the heart of my paper lies a conceptual shift in the understanding of conflict. Rather than viewing disputes as purely legal disagreements, I argue and adopt a relational perspective. Conflict in that framework is understood as unmet needs within a relationship. Now, this framing is significant. It shifts the focus of dispute resolution away from legal claims and toward the relational dynamics that underpin conflict. In cross-border trade, disputes are not merely about contractual terms, but also about trust, expectations, communication, and cultural interaction. Recognizing this expands the scope of dispute resolution from adjudication to engagement. Now, the Pentagon framework as a process for resolution. Now, building on that relational understanding, I propose the Pentagon framework, a structural and process-based model for conflict resolution. And that's what figure 1 is all about. And so you have to start from the bottom, gathering parties, effectively to hearing their story, to rehearing their story, to understanding them, and then moving on to resolution. Now, if that framework operates as a sequential, cumulative, and relational process, each stage builds on the previous one, deepening understanding and facilitating movement toward resolution. Unlike adversarial systems, it prioritizes process over position and emphasizes trust building before outcome generation. In doing so, it produces settlements that are not only enforceable, but also sustainable. Now, we'll look at what's going on, do some little case studies in terms of institutions in practice. So we have one OHADA, which is called harmonization in practice. The OHADA system demonstrates that legal harmonization is both possible and beneficial within the African context. Its framework provides coherence across jurisdictions and incorporates mediation as a formal mechanism. However, capacity constraints and uneven implementation continue to limit its effectiveness in practice. Now, the arbitration ops growing capacity. The emergence of arbitration centers such as the Lagos Court of Arbitration, the Cairo Regional Center for International Commercial Arbitration, and the Kigali International Arbitration Center reflects growing institutional capacity within Africa. These centers contribute to regional credibility and reduce reliance on foreign arbitrages. However, the challenges relating to enforcement and perception persist, limiting their full potential. The Singapore Convention, what I call the missing link, the Singapore Convention provides a framework for the cross-border enforcement of mediated settlement agreements, addressing a key limitation of mediation. However, limited adoption across African states has constrained its practical impact, reinforcing the dominance of arbitration. Now, what I call at the synthesis and the central role of trust. Across the institutional developments examined, a consistent pattern emerges. While progress has been made in legal harmonization, institutional capacity, and enforcement, mediation remains underdeveloped and enforcement asymmetries persist. Now, underlying these challenges is a deeper issue, which we spoke about yesterday, trust. This confirms a central insight of my paper. And I therefore submit that dispute resolution is not solely a legal process, it is a relational and institutional system grounded in trust. And then move on to talk about move towards an African first ADR ecosystem. An effective ADR system for Africa must be deliberately construed rather than incrementally assembled. I'll repeat that. An effective ADR system for Africa must be deliberately construed rather than incrementally assembled. Such a system requires integration across multiple dimensions. It must connect courts, arbitration, and mediation into a coherent framework. It must expand legal harmonization through models such as OHADA, potentially at the AfCFTA level. Again, I mentioned that yesterday, for Africa to adopt OHADA. Mediation must be repositioned as a primary mechanism rather than an afterthought. Mediation must be repositioned as a primary mechanism rather than an afterthought. Additionally, digital transformation, particularly through online dispute resolution ODR, must be leveraged to enhance accessibility and scale. Policy and practice implications. These developments carry significant implications for both policymakers and practitioners. For policymakers, the priority lies in expanding access to dispute resolution mechanisms beyond states. I cannot overemphasize that. Our policymakers drop the plates there. So they must strengthen enforcement of frameworks and invest in institutional capacity. For us practitioners, there is a need to develop cross-border expertise, integrate multi-tier dispute resolution clauses into commercial practice, and apply relational frameworks such as the Pentagon model. I think I'm moving towards the end now. In conclusion, Africa must resolve its own disputes, which is where I started. AfCFTA represents more than a trade agreement. It is a test of institutional maturity, legal innovation, and trust-building capacity. While the existing framework provides an important foundation, it remains insufficient for addressing the realities of cross-border commercial disputes. So my paper is arguing that Africa must move toward an integrated, relational, and enforceable ADR ecosystem, one grounded in indigenous traditions, supported by modern legal frameworks, and operationalized through practical methodologies such as the Pentagon framework. And ultimately, I say no trade system survives without a dispute resolution system that works. No trade system survives without a dispute resolution system that works. AfCFTA doesn't have that. We must create it. Thank you so much. So we say.
Thank you very much, Prof. This has been a paradigm shifting presentation, a masterclass in itself. I wouldn't have expected anything less from the Prof himself. So thank you so much. You've summarized everything, the AfCFTA opportunity, the ADR concept, the fact that it is not, ADR itself is not an imported concept, it is originally African, and the fact that we must be able to resolve our own disputes, and no legislation, no agreement can exist without providing for trade dispute resolution. So thank you very much, Prof. It has really been enlightening and insightful. So at this point, we'll give room for questions. I believe that there are a whole lot of questions that are running in the minds of participants at this moment. So the floor is open. You can drop your questions in the chat, or we'll give you room to unmute and speak. So questions now. I'm still looking at the chat. If you have a question, you can just indicate by raising your hand, and then I'll take your question. Okay, we have the Prof herself, but I'm in the middle of two professors this morning. I hope that I will survive. So Prof Ma, you have the floor.
Thank you very much. Thank you, Sebuse. It's just for me to say a huge thank you to Professor Olagunju and to recognize his suggestions and the way he's thought through. Of course, the AfCFTA is a trade agreement between states. So the way I think we need to also appreciate is that it's you can look at it as the public law facing side of this discourse. And what Prof has offered to us is, again, bringing it down to the micro level regarding dispute resolution for within the continent and for those who would deliver on AfCFTA. And I just wanted to reflect a little bit on the suggestion by Prof that we may consider the OHODA system. And why I think it's important that we should reflect on that is that I've heard that suggestion in a couple of other places. And I think that the AfCFTA and OHODA are different animals. They face OHODA is private law, AfCFTA is public law. And I think that it will be difficult to have the same level of harmonization that you have within OHODA because they're primarily French-speaking, civil law, share the same currency or similar, the francs. And those are important, and language. And those are a legal system. Those are strong, important connecting factors so they're much more closely aligned than, let's say, the Anglophones, for example, within the continent. And so to transmute that from OHODA, which is primarily West Central African states, to the whole continent, I think it will be a tough. I'm not convinced that would be the way to go. So, Prof, what I wanted to ask you is then, do you think, if you agree with that short conclusion that I've made, do you think that if the OHODA model was shared with other regions, do you think that would work so that the private law complements the public law aspect, so that it will complement AfCFTA goals? Do you think that might be more workable for the continent? Again, thank you very, very much for a very interesting paper.
Should I engage Emilia or should I wait for others?
Please go ahead, sir.
I can go on.
You can go on, sir.
You dropped a bomb of Ubuntu. You just dropped on Ubuntu yesterday and disappeared. So I had to explain that thing Emilia dropped is huge. And that is the summary of African dispute resolution for thousands of years. And it's very strange how we speak the same language across Africa. That's an area that I've studied and I've been looking at for 20 years. There's a convergence around what I'll call it mediation. I mean, there's issue about this traditional customary arbitration and all that, but the spirit behind Ubuntu as applied to dispute resolution in Africa is that, as she said yesterday, as Professor Emilia said yesterday, I am because you are. In other words, there's a very deep sense of community traditional to Africa. And every African child, especially if you have left Africa and go to Europe, and particularly America, you understand that sense of community I'm talking about. Africa has lived it for thousands of years. And Ubuntu captures that more than any other thing. And that's where I will begin my response to you, Ma. If we had a system that works, and actually a system that, if you look at the whole of what was going in Africa, there was some litigation, traditionally, there was arbitration, there was mediation. It's just that what they were doing, those various things, they weren't looking at them in silos. The ultimate for traditional African dispute resolution was, how do we heal the community? That as long as Professor Emilia and I have this dispute that has not been managed and resolved, the ground suffers. The community suffers. And emphasis in Africa was not on her and myself as individuals, but on resolving and healing the land. So my first point is that we cannot take that from Africa. It is still very strongly there. When that approach to dispute resolution, when he died in several other places, because it existed everywhere in Europe, when he died, it was Africa that preserved it. Africa to some extent, also India, maybe some Asia, and then Asia, particularly Japan. And they have some elements of it in North America, the cycle system and so on. So what I'm trying to say is that we already have an harmonized system in Africa. Maybe there's not enough literature on that, but there's something already in Africa. And all the ADR systems we talk about, they're not really strange to Africa. Now, specifically talking about your question, OHADA being adopted by the whole of Africa. Number one, we are both international arbitrators. We know that this ADR is now merging between the civil law systems and the common law systems. They've been finding a way to merge. And effectively, if I could explain, the civil law system is more investigatory, and the arbitrator or the judge has the leeway to ask questions to, unlike the common law system where the adjudicator may keep quiet most of the time. But what has been happening for some time now is that is merging. We're having a melange of civil law system and common law system. And so specifically to answer the question, if we created AfCFTA, we must create a dispute resolution mechanism that works across Africa. I am not saying, in fact, somebody from WADA came yesterday and said, we have challenges. I noted that. They have challenges. But the thing is that, do we say because WADA is not perfect, we should not embrace it? I don't think so. I think that if they've done the big courageous thing of united 17 countries in Africa, we should look at what can we do with it. Now, specifically on the public-private law issues, while it is, I'm about to, your superior knowledge on that, while I agree that that's the situation, our policymakers cannot make the AfCFTA, can I say, law or convention and do what they did inside it, keep quiet on how we resolve disputes around what they've created. Because AfCFTA really created business. And frankly speaking, that is one of that's probably the greatest thing that happened to Africa, because what we are talking about, if there's no economy, there's no business, there's no life. So AfCFTA is a huge development. But when we create AfCFTA and we are silent on dispute resolution mechanisms, there's a big problem there. And so if they had said, well, we'll adopt, they can even go to United Nations and say, look, we put this is what will be done in Africa. It would have been better. But to keep quiet does the service to the African business, average African business person. But I do not. So where I was explaining the civil and common law margin is to answer the question whether we should adopt OHADA. Yes, we can still adopt OHADA. When we adopt it, will no longer look like what it is now. It will change. There will be contribution from the mostly English speaking. By the way, I do not think it's only French speaking. Mostly French people there. So I think the Luzon and the South Africa, they are already joining. We need to look at it. You and I can't do it. We are academics, but our political leaders need to sit down, look at OHADA and say, is this what we should adopt for AfCFTA or adopt something else? But keeping quiet is a very dangerous thing for business. And if we don't deal with this problem, this lacuna of making this resolution state-centric in AfCFTA, then what we want to achieve with AfCFTA will be lost. And our enemies will laugh at us. Forgive me, I'm using very strong words. Because after it provides Africa an opportunity to trade within ourselves, which is the way forward for Africa, which is important for the poor in Africa, for the people of Africa. After is the way forward. But dispute is next, and it must be addressed. I'm not sure I've answered your question, Ma, but I just have attempted to address it. Thank you so much. I appreciate it.
Thank you so much, sir, for that response. So the next question is from Ambassador Wan Jiku. I hope I got that right. So she has two questions. And the first one is if the paper presented will be made accessible to participants. And then secondly, she's asking what are the 3 hindrances to the uptake of the Singapore Convention?
Did you say 3 hindrances? 3 hindrances?
Yes,
if she's asking 3 hindrances, that means she knows. That means she knows. She should tell us the 3 hindrances. Okay, so, except if she's referring to what I mentioned in the paper. But my paper, yesterday, I dropped our discussion yesterday. Like I said, what I do just right around the discussion. I dropped it on the chat yesterday. I hope you saw it. And I hope Isaac and our other handlers will share that. This one too is more or less ready. As soon as it's done, I will put the link in the chat. So look out for that. Now, the problem with, by the way, the Singapore Convention is another great thing for Africa. Why the whole of the countries in Africa, or the country Africa, will not quickly adopt it? For me, I think it's because of misunderstanding of Ubuntu. If we know that the Singapore Convention is a resuscitation as it were of Ubuntu, would have embraced it. I mean, which shows our problem in Africa. We know so much about the West. We don't know much about ourselves. And I'm also guilty. I went and did ADR in England, I mean, very high scale. And then, they gave me all the opportunity. And then I came back, I left, I wasn't feeling comfortable because any African child will know that when you mention ADR, you are talking about Ubuntu. At least you're talking about a system that any African child growing up will know this is what we're practicing in Africa. And yesterday, the sister from Cross River reminded me of that. When I talk about relational approach to conflict resolution, which is based on what is needed for this dispute to go, I've been talking about that for 20 years. And then yesterday, she said that's what her grandmother used to do in Calabar, if you remember. She said she would call people and say, okay, so what do you need for this to go? That is the summary of all the books I've been writing. And she said the woman never went to school. And so we don't know what our fathers have established. Africa has established a very strong dispute resolution system, and we need to humble ourselves and go back and learn. My mediation didn't find any headway until I did that. I started looking at what our fathers are saying. What do they mean by that? And that's how I came to this need-based approach or national approach, which, like he said, go to any village, Igbo, Yoruba, anywhere, you see them, in the evening they come and deal with these issues effectively. And whether it's a $10 billion dispute or not, our fathers have the mechanism. We should learn it. And then we'll be able to appreciate Singapore Convention, which gives it teeth. So that when you resolve a dispute at mediation, Singapore Convention says it must be resolved like a court judgment and like an arbitration agreement award. Thank you. Maybe you remind me of the other two, my sister, Ambassador. The other two, so that I can address it.
Thank you. Thank you so much, Prof. So I think one word that has been coming up since yesterday is Ubuntu.
Yes.
So nobody's allowed to leave this conference without finding out what that is. And Professor Emilia has also dropped a link in the chat as to the meaning of Ubuntu. So I think we should look it up as well. That will also help us a guide. Thank you very much, Professor Emilia. Thank you, Professor Olagunju. And okay, we have one more question from Ngozi Arunze. We'll take that final question and then we'll proceed. You are muted.
So thank you, everyone. Thank you to the two professors, more like two elephants in the room. I've really learned a lot. I really learned a lot. But when you were both sharing your own opinions, I looked at it that OHADA, Professor Emilia, if I got you right, you said OHADA is public, right? Was that what you said? It comes within the public law? Was that
Oh,
what
no,
you
it's
said?
private.
I stand to be corrected.
OHODA deals with only business, laws to do with business transactions. That's its limitation.
Okay.
Yes.
Okay, that means
private.
it falls within the private. Yes.
Yes. Yes.
More like a private. Okay. So when you were saying that, I was like, though we share some kind of a common background as Africans, as African states, we also have different legal traditions. We have diverse languages. So now, for based on what you asked or what you are proposing, that is it possible, more like a question as well, is it possible that or could other African states accept OHODA? In my thoughts, that came to my mind that because we have diverse legal traditions, it's something that we need to also look at. That it's not the way it is appreciated by the West African that kind of share some form of legal tradition, same legal tradition. I might be right, I might be wrong, but I'm just like saying my thoughts. That it's something that we first, I'm now aligning myself with Professor Olajide. We'll first propose and see how it goes. But there is also a limitation because, yes, we are talking about business and commerce. But ADR should also, if you ask me, you should go even beyond commerce because this is our life. We have other aspects that ADR deals with, but I know that the after is after commerce and like Professor Olajide said, is state-centric. That being said, both of you are right. There is no right or wrong. What Professor Emilia is saying, yes, let's propose this and let's see if they will take it. If they look at it and it aligns with the vision of AfCFTA, which is primarily, and I also align with you, Professor Olajide, that there should be a proper structure for dispute resolution making, because in all of this, the states are there, but the people that do the real business are common people. They are the SMEs and other private bodies. So thank you very much. So my question now is, Professor Olajide, that's just my thoughts. My question now is, you made mention, and this exactly was what I shared with a colleague. And immediately I mentioned, because I'm a certified mediator, I'm not an arbitrator. I hope to be like one of the two of you, because I know that you people are seasoned arbitrators. My question is with respect to mediation. Mediation is actually underappreciated. I shared this with a colleague, and immediately I mentioned, he was even thinking I am an arbitrator. Immediately I mentioned mediator. He said, as in the way he kind of blushed it off, that mediation, everybody can mediate. This was his words, everybody can mediate. In his mind, not everybody can arbitrate. So when you place it on that cadre, arbitrators are more respected. I wouldn't know, but I don't know what it takes to be, I've not gone through that training and certification. But I now want to ask, how do we then pivot mediation to be that default dispute resolution platform, that when negotiation fails, mediation on its own has its benefits, but people are even losing touch of that benefits. The answers are already there, but I want a shared experience from you, if possible, a lived experience from you, because I could even see what the Central Bank of Nigeria, what they are proposing now to have a mediation panel for security-lended transaction. Prof. Onyema, am I right on that? Yes, with respect to the Central Bank of Nigeria. Yes, there's this proposition from them that everything that has to do with security-lended transactions must first go through mediation panel. That as at April, I saw that in the news. So if the mediation is institutionalized, I know it will go a long way. But let me have a shared experience. Forget all these talkings. I have learned a whole lot. I appreciate you all, and I hope to engage further on this. Thank you very much. Did you get my question, Professor Olajide? It has to do with mediation.
We understood you. I don't know whether my
To
sister,
the extent that
Mr. Billy, do you want to engage it first?
arbitration.
And, you want to look at it first, and then, or Professor Miller, do you want to look at it first, or you want to take the first take?
I think, Prof, one of the things for us to think about is that we can't say that only one type of dispute resolution mechanism or one system should work. No, it's because disputes are different and dispute resolution mechanisms are different. There is a whole if you like, stretch of different types of dispute resolution mechanisms. And what we need to be thinking about, which is the idea behind the multi-door courthouse system, is which mechanism or which dispute resolution process is best for this particular dispute to enable us achieve what Prof was talking about. And that's basically what Prof is saying. Prof is not saying, from my understanding of what Prof has written and what he's saying and what he has said today, Prof is not saying that it can only be mediation. I practice arbitration. I'm not saying that it can only be arbitration. At the same time, there will be disputes that ideally must go to the courts. And so we know that we do have a scale where you have, if you like, starting with a negotiation all the way with all these other differences, all the way to litigation. We must have the states involved because the state has enforcement powers. So you can do your mediation and we can agree, and then I leave the mediation and I change my mind. What do you want Prof to do? To fold his hands and say, well, I don't have any option? Or is he going to resort to self-help? No, we need the courts. We need that, if you like, that net, safety net, so that if these ones do not ultimately transform into a tangible benefit for the party or the parties, there is somewhere to go that somebody can force you to do what you have already agreed to do. So I think that's the way we're reconceptualizing it. And that's my understanding of the presentation. That aligns with my view. It's just that before Prof comes back to round us up, I was thinking, Prof, because Prof said something around, yes, we are academics. We can sort of rethink all of this, but we don't have the powers to change because we're not the state, the status quo. But I think that we do have powers because as we disseminate knowledge, we can also conceptualize a structure, as Prof has shown us the Pentagon framework. We can work out a structure and encourage parties to try this so that we take a bottom-up approach. If people begin to use that, it becomes a lot easier to find a framework that would work across the continent. But we must have the state engage at some point. I'm going to put a link to a book published by an academic here in the UK, where she looked at traditional dispute resolution processes across Nigeria, UK, US, and a couple other countries, just to give people an idea. I think Prof already said stuff around that. Prof, over to you.
Thank you so much. Thank you. I'm very grateful for that intervention. First, I begin with about mediation. If you've read my book, How to Resolve a Conflict, in chapter 4, the heading is When Mediation Works. And I showed several situations where it may not work. So I want to start because she touched on. I want to emphasize that I would never say that mediation is the only way. But I would say, and I have no doubt about that, I think is the number one way, and I think it's the first step in the gamut. Professor Emilia was talking about the gamut of dispute resolution, from negotiation to litigation. So if we talk and we can't work negotiation, mediation is the best thing. And in fact, today, mediation is going to go until we're able to talk to each other directly. Because what is mediation? Mediation is assisted negotiation. Simple. Now, in the paper I said three people should be talking: the courts, the arbitrators, and the mediators. So again, to say that we must have a marriage of all three. And the reason I've been given by Professor Emilia to have finality and firmness. Now, there's something you said which I need to look at, Ngozi. I would never agree that it is more difficult to arbitrate than to mediate. As I told you yesterday, I came into mediation in 1995 in England. It was coming to England then, they call it ADR. And at the same time, I studied arbitration. I had a soft spot for mediation. When I came back to Nigeria, I presented myself as a mediator. It was new in Nigeria. Unfortunately, it's still relatively new. And the first brief I got was not a mediation brief, it was an arbitration brief. Now, so I'm saying that to say that after 31 years, I can tell you confidently that it is easier for me to do an arbitration than to do a mediation. Mediation is a very, very complex thing. Because what is mediation? Mediation is getting the parties to determine for them what is the outcome of a dispute. That's a simple understanding of mediation. Getting the parties, getting them to agree, emphasis on agree on what is the outcome of their dispute. What's arbitration? Professor Emilia and any arbitrator will agree with you that arbitration is telling them what to do. So who is an arbitrator? Arbitrator is a judge. For me, the only difficulty is what are the rules? What are the laws? What does CITRA say? What does the Arbitration and Mediation Act say? And so on and so forth in the particular jurisdiction I'm dealing with. And I don't even need to know them. At least none of them. The lawyers will come. They will tell me, Your Honor, what do they call arbitrator? This. And then I sit down and I tell them who is right, who is wrong. And there's nothing they can do about it against an award. You can't appeal. Except you say, oh, well, actually, the chairman is the husband of the lead lawyer of the other side. Things like that, on ethical issue and justice issue and fair hearing issue. But on the content of the arbitration, there's nothing you can do. So for me, my experience 31 years is that it is more challenging to be a mediator than to be an arbitrator. So it's, in a way, if you want to talk about superiority, it is a superior system. And that is why when we see our elders do it, don't think it's easy. They learned, and the sister that brought it yesterday from Calabar said, oh, my grandmother is not educated and all that. It is not true. They learned it over the years. And then they became experts. That's why at the time they called them Lolo or chief. It is that education that gives them that title that makes them to be able to sit in the council of elders and mediate. So that I just wanted to say that the fact that you're a certified mediator, you are not inferior to any arbitrator from anywhere in the world. If you want to rank them, you are superior, because they cannot do what you can do. If you're a good mediator, and I assume you're a good mediator from listening to you, I think I've addressed that. In terms of what to do to move forward concretely, we have to go back. Thank you, Professor Miller, for correcting me on that. We have to go back to our policymakers. We have to know that academically we have something to say and we can get our word across. We have to go back to our policymakers. One, to say that what we are talking about is not strange to Africa. Two, that what you have given us, we are grateful, but we need more. How are we going to resolve business disputes in Africa? Let's just have I would say a law or a convention agreement on that. If we can create OAU, which is now African Union, and if we can create AfCFTA and other things that Africa is doing together, we should be able to create a dispute resolution mechanism that will govern business in Africa. I'm not sure I answer your question, Ngozi, but that was just an attempt. Thank you so much.
Prof, before I can see that Isaac and Sewuse want to quickly come into this conversation and stop us. But before they do that, in 2020, I had actually written a paper, published a paper on a continental view, but again, just commercial arbitration, on a continental view of how we may possibly do this for trade, for intra-Africa trade, disputes arising out of intra-Africa trade, taking the perspective that we should adopt arbitration, as you can imagine, and trying to figure out what exactly is the problem that we face on the continent. And the fact that the problem we actually face on the continent is the disconnect with judiciaries, with courts, in enforcement of arbitration agreements, enforcement of awards and challenge, and then adopted your suggestion, which is the OHODA system, but transmuted it and suggested a continental court with limited jurisdiction for enforcement and challenge of awards. Now, it's similar to the CCJ of OHODA because that's one court that you go to, and if they enforce your award, then you can enforce it in the 54 African countries. If they set it aside, that's it. You can't go anywhere else with it. But that takes it out of national systems and projects it onto a continental level so that it would support intra-Africa trade. So that was in 2020, and I put the link to the paper in the chat. It might be something that some people will find interesting, and maybe that's something to reimagine in terms of mediation or conciliation, adopting systems or ideas out of the Singapore Convention to say that, this is something else that we can do and expand the scope of the processes that we can adopt for cross-border transactions, even conflicts, for example, but we leave out domestic regimes. African countries, they love their sovereignty so that we don't step too much on their toes.
Yeah, that's awesome. I've picked the paper and I'm going to look at it. I think that actually you are talking about what I'm actually talking about. So I'm going to look at it and then see how we could develop other ADR processes into it. So I appreciate that. Thank you so much.
Okay, so thank you. I think I have a question for the two professors. We are not stopping you. I think I have a question for the two of you. So when you look at the UN system, although they created the WTO, which is the World Trade Organization, Africa has also created AfCFTA. The UN system went ahead to create UNCITRAL, to put working groups together to keep working on trade laws across the continent, and also to make sure that they provide dispute resolution rules on mediation, on conciliation, and arbitration for especially non-state actors who do not want to use even institutions to run the arbitration or mediation. What do you think Africa can also do in our system from AU or even within the AfCFTA? Can't we put a working group together where we can be looking at these issues of whether to go the direction of OHADA, whether to have a separate rule which will come under the AU system so that it can be used, especially for non-state actors, dispute resolution, whether they want to use institutional rule or they want to go on ad hoc basis. What are your thoughts on that?
I totally, forgive me, I'm jumping in. I totally agree. That's the way to go. That's the commonsensical way to go. That's the commonsensical way to go. And the earlier we did it, the better. If we look at yesterday, I'm sorry that I have to come back to her. She was saying somebody from AfCFTA told her that they did it because of protect. That failure to provide for dispute resolution in AfCFTA is more dangerous for Africa than whatever they are trying to protect. So, I mean, I agree with you. It has to be done. Something has to be crafted. So thank you very much.
I do agree, subject to the fact that, again, let's be scientific in what we do. So quite a number of, let's take arbitration, for example, quite a number of the arbitration laws we have on the continent that have been modernized follow the UNCITRAL model law regime. And then the arbitration rules of almost everybody follows at least that's their starting point. So the point then being, we don't need to reinvent some or everything, bearing in mind that African countries participate actively in UN body and UN agencies, their activities. So maybe it will be to take those as a starting point. And then I think the issues that Prof. Olagunju has shared with us, especially this whole idea of communitarianism, is really important because that's what distinguishes us. That's what is very African. We're thinking of the whole and not just the dot. So it's not just I, but all of us. And then how do we bring that into, so what can we add to what is already there to make it distinctively African? And then we're giving something to the world as well. And so places like New Zealand that now have a stronger sense of communities and indigenous peoples may find, when we do the addition, if you like, may find that equally useful. There are quite a number of international agencies, organizations, intergovernmental agencies and organizations. So like the UNIDROIT, the work that they're doing. So in other words, what is already there that we don't need to start afresh with, that we can take what they have, and then so that what we are thinking about is what is unique to the way we live, to the way we do things, to our understanding of these issues that we can bring into those. What is it that is too non-African that we need to take away? It can also be a question of something that this is not where we are at our level of development. It's too high-ended for us because we want it to be organic. We want to grow into it. Bearing in mind that it's not only all of us who are at this conference, but we're also thinking for the market woman. And that is really dear to my heart. We're thinking for the taxi driver. We're thinking for those in the informal sector that do not have legal advice. So what can they identify easily? Which is what Prof is saying about the lady who talked about the grandmother, about our traditional way of doing things. There are certain things that just come innately to us as Africans. Can we identify those? And can we pull those into a continental framework that would then govern for we the small people, the people who would deliver this intra-Africa trade? Can we do that?
Thank you so much.
Thank you.
When I earlier said that I was in trouble finding myself in the list of two professors, I think that it is obviously very clear. But thank you so much. It has been really, really, really insightful. And I could go on and on and on and on, but we just have to stop at this point so that we can proceed. So thank you so much, Professor Amelia. Thank you so much, Professor Olagunju. We really appreciate and we gained so much, so much. So over to Mr. Isaac. I think we'll take a short at this point before we'll now proceed into the next session.
Okay, thank you. So we say, I think please, for those who are able to kindly put on your cameras, let's take a picture together. Thank you so much. want to take a picture with all of you. All right, some of you, please, if you can take a look at your camera. Some of you are turned sideways. I think Victoria, check your camera. You've turned sideways.
Isaac, is it better now?
No,
Could that
still.
be one? Oh, okay, I'll try to figure that out. Thanks.
Okay. Okay, so in 3, 2, 1, we're taking the shot. Okay, the first one. Okay, thank you so much. I think, yes, Victoria, your camera is better now.
Thanks.
Yes, the next program, so we say, bear with me. The next program is supposed to be a presentation from Faith. Is Faith around? And the next panel, I think we have eaten into their time, the panel discussion for the next session. Is Tina still around?
I'm here, Isaac.
Okay, is Joseph around? Joseph George?
He is.
Is Jude around?
Yes, I'm around.
Okay. And so, Faith, if you can bear with us, we want to take their session. They have other commitment that they have to leave. If you can bear with us, we take their session, then we come back to your session. Can we have an agreement on that? Faith, you want to hear you. You are muted. Hello, Faith. Yes.
Yes, I'm here. I do have work. Can you hear me?
Yes, yes.
I do have work, and so I don't know how long they are going to take. It's currently 5:22 at my end, and so I don't know.
Okay, so Tina, how many minutes do you have before you leave?
Ms. Faith, thank you for being honest. Continue on with the agenda as stated. I'll need to sign off, but my panelists can handle the commitments that they've agreed to. So thank you for that.
So I don't have work until 9, but I do have to drive. So if you might be done by 7, that might be okay. I meant 7 a.m. my time. That's about
Okay.
2 hours from now. I don't know how long the panel discussion is going to take.
We had originally agreed to 40 minutes. We would actually take less than that, but if you need to get on the road, we'll do what we can do.
Okay, so that's fine. You can do your presentation since it's just 40 minutes.
Okay, so Tina, your batch have the platform now. So thank you. You can introduce yourself and bring in your panel members. Thank you. And thank you, Faith, for your understanding. Great.
Thank you, Ms. Faith. Hello, everyone. I'm Tina Patterson. I'm founder and principal of Jade Solutions, based in the United States, but I sent you greetings from the UK. I am pleased to share with you that our panel represents 3 continents. I'm going to introduce all of our panelists, and they are going to be talking about alternative dispute resolution and AfCCTA. With us today is Mr. Mokum, a barrister, solicitor, and notary public with residence in the Northwest region of Cameroon, one of the English-speaking regions. He is the bar president's representative for the said region, a member of the Chartered Institute of Arbitrators, and co-founder of the newly instituted Arbitration and Mediation Center called the Central Africa Arbitration and Mediation Center. He has been practicing law for 15 years. Also with us today is Mr. Joseph George, an internationally recognized arbitrator, mediator, crisis hostage negotiator, keynote speaker, and dispute resolution trainer with extensive experience resolving complex, multiple disputes, across multiple industries. As a partner with George and George Group, ADR Group, he has successfully mediated and arbitrated matters involving construction, employment, commercial contracts, landlord-tenant disputes, homeowners associations, lemon law claims, and high-value business conflicts. In addition to his work as a neutral, he is a certified hostage and crisis negotiator, bringing advanced communication, de-escalation, and problem-solving skills to challenging situations. I did mention we have all three continents represented today, and so we've had the US as well as Africa. Now we'll hear from our panelist from Australia. Mr. Amiel is an Australian award-winning writer, mediator, restoration justice practitioner, and peace builder. He is the principal consultant with Comprehensive Mediation Services. He works across community, family, workplace, and cross-cultural disputes, supporting individuals, organizations, and communities to navigate conflict, relationships, and build social cohesion. I will share this with you now that Mr. Mokum is going to be talking about the origins of AfCFTA. You will hear from Mr. Amiel. He will talk about challenges and recommendations. And Mr. George is going to be speaking about the enforceability of ADR and AfCFTA. I know you may not see me towards the end. I do have another commitment that I need to step to, but Mr. Mokum, you now have the floor.
Thank you, Mrs. Tina. We are looking at ADR and investment disputes under AfCFTA. The African Continental Free Trade Area, I consider it as one of the pride of the AU, given that it's an African institution that reflects the Ubuntu as expressed by the program.
I gotta finish this here and then
the AfCFTA has as one of its objectives establishing a unified mechanism for dispute settlement across state parties, as opposed to the previous mechanisms of dispute settlement, which were more westernized in character, like the Investor State Dispute Settlement, the ISDS, through forums like International Center for Settlement of Investment Disputes. The AfCFTA came in with a functional system which came in to remedy the criticisms from the African states of the ISDS because of high costs, perceived bias, and threats to regulatory sovereignty. The AfCFTA Protocol on Investment is a complete reconstruction which prioritizes state sovereignty, dispute prevention, and domestic AR mechanisms. In a bid to achieve its objectives of a cut-across dispute settlement mechanism, AfCFTA has a dispute settlement mechanism which is called the Dispute Settlement Body, DSB, established after Article 20 of the AfCFTA Agreement and governed by the Protocol on Rules and Procedure of Settlement of Disputes. Formally launched in April 26, 2021, like NCR, like KIAC, like CCJA, it establishes dispute settlement panels as well as appellate bodies, which reports it adopts. In line with relevant provisions of the agreement and protocol, disputes unfortunately can only be tabled by state parties. Settlement of disputes, we look at settlement of disputes via ADR mechanism. Though AfCFTA dispute settlement is governed by a dispute settlement body, that's the DSB, Article 7 of the AfCFTA agreement and Article 46 of the protocol gives room for settlement of disputes via ADR mechanisms at first instance. The protocol therefore establishes a multi-tier dispute resolution framework with state parties obliged to attempt amicable settlement before resorting to settlement via DSB. Therefore, for state parties to request for the establishment of an adversarial adjudication panel under the DSB, they must have, as the practice demands, within 60 days fail to arrive at a settlement, either through consultation, negotiation, or mediation. However, in situations where the parties choose to go by arbitration, then they are turned out from the option of making use of DSB, given that the awards remain binding. The elements that travel with ADR mechanisms are also put in place in respect of the obligatory principle of confidentiality and neutrality, with the resultant outcome that preserves the diplomatic relations between state parties, albeit emerging from a dispute. If the non-tariff barrier monitoring mechanism supports digital complaint handling and can thus support technological options in settlement by ADR mechanisms such as e-filing, online case management, virtual hearings to reduce costs given the nature of disputes being transcontinental. With regards to the challenges, I will let my colleagues in the panel come in on that, and then probably I will come in to add equally on in the area of recommendations. Thank you, Tina.
Okay, thank you, Mokom. Now let's move on to Joseph. Joseph George, are you there? Can you hear me?
Yes, I'm here.
Yes, if you can put your video on so that we can see you, I'll put you on the spotlight, if that is okay for you.
Yes, that's fine.
Okay. All right, thank you. So we want to hear your thoughts on the topic. Please, the floor is yours.
Okay, so let me see if I could find my file first. Give me just a second here. Seems like it's, give me a second. If they want to do questions at the time, it's fine. Let me see if I could find my, let me see, entire screen.
Yeah, George, while looking for your file, maybe I just go on.
Yeah,
Then you
that's
come
fine.
back. Yeah. So talking about challenges with respect to the application of ADR mechanisms under the AfCFTA option. The ADR mechanism contemplated by Article 7 of the agreement and Article 46 of the protocol, that is consultations, conciliation, negotiation, and mediation, produces outcome in settlements that are not binding, and except the states are part of the Singapore Convention, they are signatories, decisions or awards or recommendations by mediation will certainly face issues with enforcement. However, awards from arbitration can be enforced through the state parties if they have ratified the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. We look at limited access to investors. The dispute settlement protocol limits its application only to disputes between member states, and thus disputes between an investor and a member state will not be entertained should the investor fail to obtain diplomatic protection from a state to assist seize the DSB. Very little business is done by the states, and therefore I wonder how AfCFTA intends to achieve its goal to promote investment when investors still see the DSB as far and underreaching. George, are you there?
Yeah, I'm here. I have to sign on my other computer. This computer is not allowing me to do what.
Okay, sorry about that. I think maybe if there is a question for Mokom, thank you for the insight that you've shared. If there is a question for Mokom or contribution someone wants to share on that, someone can bring it up at this stage whilst we wait for George to fix the issue and join us again. Okay. Any question from anyone? Okay, Ngozi, your hand is up. Please go ahead.
It's a learning curve for me, so I keep asking questions. You said that Mr. Mokum, Barrister Mokum.
Yes, please.
Now, what applies based on your last statement? You said that arbitration scales through. I'm not quoting you verbatim, but that's my understanding. I stand to be corrected. Thank you. So arbitration scales through if state parties have ratified the New York Convention. That's right. Was that your position? Then,
with regards to enforcement.
With regards to enforcement, yes.
Yes.
With regards to enforcement. So now I'm asking for mediated settlement or settlements between the parties, mediated settlement. It will not be enforced if parties are not treated to Singapore Convention. Not be, yes. So my question now is, when the parties, with respect to arbitration, they have not ratified New York Convention. They have not ratified. Does that stand as well? Did you get my question?
Yes. Okay. Because now they will have to face the hurdles, maybe at the level of the national, the states, with reference to their local laws. Like yesterday, I was talking about the exequatur that has to be obtained from the other states when the arbitration is done by the local institutions and not the CCJ arbitration rules.
Okay. Please, I don't know if you can. I really want to get this because from what I got, is as if that mediation stands stands at the loose end more than arbitration when it comes to recognition and enforcement within the AfCFTA framework. So I stand to be correct. Like I said, it's a learning curve.
Mm-hmm. Yes, Madam Donsi, that's fine. I know you're a mediator and you're worried. They stand on the same platform in as much as they are not members or signatories of these conventions. Because with regards to awards from arbitration, you must be a signatory to the New York Convention to ease recognition and enforcement. And with regards to mediation, it is a similar situation. Fortunately for the Ohada region, we have a law of mediation that comes in at the level of enforcement to push it on the same platform with the awards from arbitration. So like I said, it's all about being signatories to conventions for implementations to go east.
Okay, so in other words, if you are signatories to OHADA rules apply. All right.
Yes.
All right. That settles that. Okay. Thank you so much. It's clearer now.
You're
Thank
welcome.
you. I appreciate it.
Okay.
Okay, thank you so much, Jude. I think George is back down. So, George, if you can put your videos on, we can see your screen now, and you take it forward. Ameo, if you are also here, please let us know that you are here. I can't see you in the participant list. Ameo from Australia, if you are here, can let us know. Thank you. So, George, the floor is yours. Please go ahead.
Okay. Thank you so much. Can everybody hear me clearly?
Yes.
Okay. Thank you so much for having me here. It's a great pleasure to be here to be part of this great conference of 2026 for the Africa ADR and the Africa Center for Collaborative Dispute Resolution to shed light on enforceability. That's what I'll be pretty much talking about today, is enforceability. As you know, contracts are not enforceable if both parties don't have the proper signature on the contract. In certain areas, like the United States, there is verbal contracts where if you and a party have a conversation and you guys agreed upon verbally, those are taken into the law. But it's certain context is still hard to be convened because there's no drafted of a contract for the parties. But in Africa, everything is a little bit different as Africa is growing drastically in the ADR field. So the foundation of the enforceability in Africa, as you can see on the screen, hope everybody could see it. ADR is only effective when outcomes can be enforced. Enforcement builds trust in arbitration and mediation. And I like to express that part there closely, that without trust in the process, neither side wants to agree on anything. So that's why trust is very important for both parties. And having an enforceable contract that's drafted very well by an attorney for the particular area of practice is always good. I like to stress that I know there's a lot of online platforms that you could grab contracts for your business, grab them, pull them down, fill them in, and then send it out to the person who you want to have the agreement with. But those are only templates for your particular industry. You need drafted context for that particular contract for your business, such as an ADR clause. Let me move this over here a little bit. The Zoom thing needs to move. Give me just a second. Let me put it out of the way. There we go. Strong enforcement promotes trade and investment. And I'm gonna read through this here just because I have arbitration coming up in the next couple of minutes. So bear with me. This is one of the oldest arbitration and mediation things in New York Convention. That's a very strong one that mostly everybody uses, even for maritime, uses that also. Recognition and enforcement of foreign arbitral awards. Many African states are signatories, enhance investments, confidence, and cross-border commerce. That New York one's been around for a very, very long time. It's like one of the oldest. I think it's actually the template that most people actually use today. Single Africa market requires predictability, disputes resolution, harmonized enforcement standards are essential, and ADR supports economic integration. So when we're using dispute resolution, it helps us to integrate into different categories as well as enforcing the contracts that we proceed in those areas of practice. So again, strong contracts create great outcomes if you have to go to court. Enforcement of mediated settlements. Growing use of mediation in Africa. Singapore, you hear my counterparts, partners on here, all of them have talked about the Singapore Convention. Singapore is one of the growing overseas also. They're escalating very quickly. So you'll continue to hear that, not just from me, but from my other colleagues also. You'll continue to hear that with the Singapore Convention. Provides enforcement framework, encourages efficient dispute resolution. Judicial support for ADR. Courts play a critical role in enforcement. Pro-enforcement judicial approaches increase confidence. Specialized commercial courts improve outcomes. The court sometimes is good when you have an ADR, an arbitration award, and for some reason one party wants to go to court to enforce that arbitration award. The courts is good for enforcing that award also, even though it's binding and the parties have to allow to it. I've seen where people still have to actually take the other party to court on an arbitration award to have it to be enforced. Same as mediation settlements agreements. Most mediation settlement agreements, I know for me particularly, but most of them have a default clause, states that if one party does not adhere to the outcome within the contract, it's usually the defendant. Then there's a dispute resolution where you file an affidavit with the court and you could seek whatever judgment you need to seek against that other party. So settlement agreements is great to be enforced into the courts. And being that we are growing so fast with mediation, and a lot of courts have extremely enforced a lot of things within courts. But of course, you have court delays. That's one of the challenges of enforcement. You have court delays because the courts are backlogged. That's why a lot of the courts are sending a lot of things to arbitration or mediation. They're still playing catch up, believe it or not, since COVID. And then some courts, depending on the area you're in, there have been storms and other things that has backlogged the courts. Inconsistent judicial interpretation. That part of consistent judicial interpretation, that's where it comes. If you draft an arbitration award, it's very effective that you make sure you, the panel that you're on and the bylaws that panel has, make sure that you are adhering to that panel's bylaws and not using somebody else's bylaws, because then that creates the wrong interpretation of what the judge would need to enforce that arbitration award or that mediation stipulation. So you got to know the state, the area that you're in, the country. If you're international like me, then you have to know those international laws in the country that you're working in to make sure you're drafting in the right language within to that stipulation, so you don't fall into issues in enforceability when a judge has to review your stipulation or when the judge has to review your arbitration award. They need to make sure that that language is in there for the area that you're in, or again, a country or continent. Limited ADR awareness. As you know, ADR is still limited because most people still, as far as the public, still don't understand what arbitration and mediation is. So it's up to all of us, and I say all of us, in order to grow this in not just Africa, but as well as globally, we all always have to tell people what mediation is, what arbitration is, so we can grow the industry for the generations to come. Because not only is it better for them, but also it's quicker than the litigation process. And especially in construction, they don't like to be tied up in court waiting on a case, because they still have to build that, convention center, build that home, build a dock, build a home, etc. So political and institutional challenges are always going to play a part in what we do. I like to say politics, I don't know who is shooting for us in our government, out there promoting ADR in the government to say, hey, the ADR industry is a very effective industry to actually grow it in Africa as well as other areas of the world. But we definitely need somebody to advocate for ADR within the government industry to let them see what we are. That way they could increase some type of laws that would make people go to see either arbitration or mediation first before they can go to court. Regional framework, ODA promotes harmonized business law, Uniform Act of Arbitration supports enforcement, serve as a model for regional cooperation. When you're dealing with businesses, it's a whole different ballgame because you have partners who you may have one partner who feels that they deserve more money or more percentage within the partnership. So, you want to make sure, again, business partnership contract is ideal and they drafted pretty good. Investor-state dispute, when you have a couple more slides, and then we'll be done. Investor-state dispute. Investors require certain predictability. Investors always look at risk management. So when you're dealing with investors, they look at risk management. That's their biggest thing. They want to know, is it worth the risk? How much risk is there? So that's why you'll have investors looking over your contracts, they're looking over your business, they're looking over your finances because they want to know what risk is there. Same as contracts. They want to know what they're in it for. Effective enforcement attracts foreign direct investment, reduce political and commercial risk. Everybody always look at risk. Technology and ODR. Digital case management system has spun out of control recently. A lot of things is going online, such as online signatures, online dispute resolution platforms is growing. Africa is online with that same path as the rest of the world, as trying to get online platforms out there to do ADR practices on those platforms, same as interpretations and anything that we're seeing, even hostage negotiations is even going online on certain platforms and crisis management. So that will improve access to the justice across Africa once that fully gets up and running. So Africa is not far behind from other countries. Africa is actually in line with a lot of other countries that I've seen. Same as India. I got to throw India in there also because India and Africa, it seems like they're running a close race. Building an ADR-friendly Africa. Ratify international conventions, strengthen national ADR laws, increase judicial training, like what we're in today. Mr. Isaac is one of the many that's at the forefront of training mediators and arbitrators, as well as paralegals and attorneys in the ADR field, as well as other fields, to grow the legal practice to help Africa grow in this area also. And promoting awareness among businesses. If you promote it among businesses, I think that's going to help too, because a lot of businesses that's in Africa, they need ADR practices because a lot of them can't go to court for some reason. But if they know they could use an arbitration or mediation practice to resolve their dispute, then it's quicker and faster for them. Yeah, my last slide. An award or settlement has little value if it cannot be enforced. Enforceability remains the cornerstone of ADR, investors' confidence and economic integration in Africa. So thank you guys so much for allowing me to be here to do this presentation for you guys. Mr. Isaac, it's always a great, great pleasure. And I could take any questions.
Thank you. I think Professor Amelia has some intervention to make. I think she put something in the chat. Prof, if you can come in.
Thank you very much, Joseph and Mr. Barrister Mokom. Thank you for your presentations. It's just to say that Africa is a continent of 54 different countries that are very different. So we do not compare continents and countries. And that is really important, whether in research or in analysis or conferences. It's massively important, whether it is in an Africa-related event or especially in non-African related event. that we do please take that into consideration, so we can't compare a market of 1.4 billion people to India or China or whoever. Okay, just so that was what I put in the chat. But otherwise, thank you so very much for your
Thank you
presentation.
so much. And
Okay,
I know
thank
if it's up to Mr. Isaac, I know he's gonna hit every single continent by the 2028.
Thank you so much, George, and thank you so much, Jude, for your presentation. Please, the platform is open for questions for them. If you have any question or input to make, please, the platform is open. Yes, Ngozi, please go ahead. Your hand is up.
Okay, so thank you, Mr. Joseph, for that contribution. I presume you are African by descent, just a presumption.
Yes.
So thank you. It's just like you reintegrating with your people. So thank you very much for that wonderful contribution. And also thank you, Professor Onyema. You have an eagle's eye. Immediately he said that I knew that Professor Onyema was gonna come. She was gonna spot that out. But thank you. I saw that big heart in you in trying to contribute to Africa's growth with respect to ADR. So it's just an observation. I picked out something from your presentation where you said OHADA serves a model for regional cooperation. And in my mind, I was like, this was what, if you had followed us from the beginning, you would have seen the two big elephants. That's what I call them for today, the two erudite scholars. So we discussed extensively on this, and you now aligning to that very thought that OHADA can serve as a model. It shows that our thought process on that is not isolated. For lack of a better word, is not isolated. So if it's possible for you to still throw in more light on this, because we are all here to learn. If there are suggestions, contributions, I know it's a statement, it's a holistic statement, but I want you now to take it piece by piece. Okay, what is your own contribution? How do you think OHADA can actually serve the greater after now? Because OHADA is 17 states. 17 states have actually ratified that, as against 54 minus 17. My maths can be bad sometimes, but do the mathematics. You see, how do we now cross carpet to that? Thank you very much. All right,
Thank you. Before even George comes in to answer that question, I think Amir is here. He's part of that panel. Amir, if you can hear me, put on your video and your mic if you can add it to the spotlight. Amir is part of that panel. Amir, if you are here, I think I saw you somewhere. You can put on your video and Amir, can you hear me? Amir from Australia, can you hear me? Okay, George, please go ahead with your answer.
So I think in order to grow it, I think you're going to need ambassadors throughout the different states. Need to promote a lot of campaign, a lot of online messaging on what it is, create some explainer videos, promote it on LinkedIn so everybody could get and understand it. Because in order for you to escalate something, you definitely have to promote it and increase a lot more education on the purpose of it and the benefits of it. That's all I have to say on that there right now.
Okay, thank you so much. Amir, if you have, if you are available. Amir, if you can hear me, are you there? Okay, Malcolm, you wanted to bring some intervention.
Yeah, just to add with regards to the issue raised by Ngozi. I think it is more about when we talk about OHADA expanding it throughout the continent, it's more about the vision. When you look at the vision of OHADA and the application of OHADA within the 17 states, you look at the successes, and I think it's something that we can use as an example if we want to look, we are looking for something African to expand that vision to the continent, the entire continent. It is probably just to take, it's a legal system that is certainly built on the civil law system, but the coming in with the common law system will simply just need a few adjustments to reflect the cross-section, a cross-section of the two systems, and we get something that is African in nature.
Okay, thank you so much, Jude. I think Prof. hand is up again, so please.
Thank you very much, Barrister Malcolm, for that contribution. I think we need to not romanticize OHADA too much, bearing in mind that as an idea, it is one, I agree with Barrister Malcolm, that as an idea, it is one that other regions need to think about, and even if it's possible on the continent. I think we discussed that before this panel. But the question really is how African, quote unquote, is OHADA and its uniform acts. It is not African. These are more modern civil law rules on those 11 model uniform acts. And so it's not, it can't, it makes zero sense to apply, to just, do copy and paste of OHADA. I think we want to move away from that. And from the last panel, the discussion we had was maybe there's some way we can take the OHADA system and then engage with the uniform acts and see whether there is something that we can retain and what we can add on to that will reflect what we understand as the way we want to operate on the continent. I'll give you a very simple example. The OHADA Uniform Act on Carriage of Goods by Road is verbatim the International Convention on Carriage of Goods by Road. That is nothing organic to OHADA. It doesn't mean it is wrong. It's just that we need to understand what it is, where the content of the laws come from, and whether they actually serve or will serve the purposes of our own constituents. And then to tweak and amend. But as an idea, I agree with you. I think it's a very good idea. But, it's not a panacea. It doesn't fix all the problems. And we can see that with OHADA itself after almost 30 years. So thank you.
Okay, thank you so much, Prof, for that intervention. I think, Mary, your hand was up. Let me give you the platform to you, Mary. Mary Amukom, if I'm right. Hello, Mary Amukom, if you are there. Okay, Amel, is your network okay now? Okay, if the network is not okay, then let me hand over to Sewese so that she can introduce Faith to go on with her presentation. Thank you.
Thank you so much.
Thank you. Okay, so thank you so much, Barrister Malcolm and Joseph George, for that session. We are grateful to all of you for making time for this. So Sewese, please, over to you. Thank you.
Thank you so much, Mr. Isaac. So we're moving on to a very important session now. It's a topic that is rapidly transforming dispute resolution in Africa and across the globe. Technology, online dispute resolution, and the future of ADR in Africa. And to take us on this topic is Faith Dedegono Williams. She's a conflict resolution professional with experience in mediation, dispute review, and conflict analysis. She's currently serving as the chair of the American Bar Association Dispute Resolution Section International Committee Planning Subcommittee, where she contributes to initiatives focused on international dispute resolution, collaboration, and professional engagement. Faith is also the founder of the Dede Foundation, an initiative focused on community impact, empowerment, and social development. She brings strong analytical abilities, excellent written communication skills, and calm solution-oriented approach to complex situations. Faith is open to opportunities in conflict analysis, mediation, conflict prevention, peace building, and dispute resolution roles. So thank you so much, Faith, for your patience and for making our time to be here with us today. You have the floor.
Thank you so much, Sawasi, for that wonderful introduction. If you permit me, I'd like to share my screen. Yeah, so my name is Faith, and I would like to start with a little bit of a story. So I'm sure many people have been faced with lots of conflicts. And so in this scenario, let's assume that you are a cocoa exploiter and you exploit cocoa from Ghana to Kenya. And your client in Kenya tells you that, oh, they've not received the cocoa, even though it shows from DHL that they've actually received the cocoa. And so there is a conflict. In the 21st century, usually conflict was resolved through litigation, and so that means you will spend lots of money to go to court to resolve your conflict. But as of now, we can resolve our conflict through mediation, negotiation, or arbitration. And it's very important because you don't really need to meet at the center or a place to resolve conflicts, because if you are all from different parts of the world, you can just use technology as a way to resolve conflict. You could use Zoom to resolve that conflict that you have. And so that brings me to a very important topic. And we ask ourselves, how does technology or online dispute resolution aid in the future of ADR in Africa? It's important for us to look at the very overview of this discussion. We'll be talking about the evolution of alternative dispute resolution. We'll also move on to talk about the rise of online dispute resolution in our community as of 2026. We'll talk about technology and artificial intelligence in ADR. We'll also look at the state of ADR in Africa. And we'll talk about opportunities and strategy and ways that we can position ourselves for the future of ADR in Africa. If I'm saying ADR is just alternative dispute resolution. So before we look at the future, we have to first understand the evolution of alternative dispute resolution. So long before formal courts, African communities relied on chiefs, elders, and family heads to resolve disputes through dialogue, reconciliation, and consensus. During the 20th century, mediation, arbitration, and negotiation became recognized internally as an effective alternative ways to litigation. Today, alternative dispute resolution continues to evolve through digital platforms, making dispute resolution faster, cheaper, and more accessible. So let's look at the rise of online dispute resolution from the 90s something to the 2026. So as the rapid growth of internet access, smartphones, and digital technology has transformed the way people communicate, conduct business, and resolve disputes, as more services moved online, traditional dispute resolution methods evolved into what we call online dispute resolution. The online dispute resolution first emerged in the mid-1990s alongside the growth of e-commerce through companies such as eBay, demonstrating that millions of disputes could be resolved entirely online. So that means you do not need to meet in an institution, but your disputes can just be resolved online. And also during the COVID-19 pandemic, further accelerated the adoption of virtual hearings. While today artificial intelligence AI is used in enhancing online dispute resolution through document review, scheduling, translation, and case management. I'm sure many of you can agree with me from during the COVID-19 era, which was from 2020 to 2021, there was a whole global shutdown. And so many people had to, let's say there was lectures online. I remembered I was in the university and I had to do my classes online and stuff. And so that was also what evolved dispute resolution. So they couldn't meet in person because they had to use online tools to evolve and settle disputes. This is very important to look at the internet usage as of 2026 as compared to the global usage. So we are going to look at the global usage of internet and then the global usage of internet as well, and then the African usage of internet. So if we look at this graph, you can see for the internet penetration rate, the global market uses about 75%. So 75% of people in the whole global world are using internet as of 2026. And 42% of these people are from Africa. And 74% of the population using internet as of 2026, and 42 from Africa. If we look at mobile internet, which is our mobile phones, we have 96% from the global market and 95% from Africa. But the most important part is the annual growth rate of internet data usage. And if we see for the global market, it's increased to 3.8%. But when we take the African continent as a whole, it's increased rapidly to 8.9%. So we can all clearly agree from this graph that the African global market has really increased a lot, and they've increased their usage of technology and internet. So while the global internet penetration stands at 74, which is significantly higher than Africa, Africa remains one of the fastest growing markets in the world when it comes to internet usage. So I want all of us to ask ourselves today, as Africa becomes increasingly digitally connected, how are technology and artificial intelligence transforming the practice of alternative dispute resolution? This is a very important question that we need to ask ourselves. And so as technology transformation accelerates across the world, technology has become a driving force behind modern dispute resolution. Emerging innovators such as artificial intelligence, blockchain, cloud computing, and virtual hearing platforms are reshaping the alternative dispute resolution by improving efficiency, reducing costs, and expanding access to justice. So in my role, I serve as a mediator for the Los Angeles City Attorney Office, and I mediate cases from various parts of California. And California is pretty big, and I utilize almost all my dispute resolution online. And so it's really important because without the use of these online platforms, I will have to be driving probably 10, 20 hours or even going across states just to resolve disputes. So let's see, how is technology actually transforming alternative dispute resolution? When we take artificial intelligence, we can use artificial intelligence for document review, legal research, case summarization, settlement prediction, and language translation. So I've heard many people saying that technology might take our job. And so if we're using artificial AI is going to replace our job, and so we need to be scared. But what I'm telling you today is that we as an African continent have to position ourselves, because AI is not going anywhere and it's only going to get stronger. So we need to position ourselves on how we can use these AI tools. Even lots of people can build their own AI tools. So right now, when I do any mediation, I have my personal AI tool. I call it Modo. Modo is always there for my mediation. It takes notes and it helps me when I'm doing my mediation. So we need to learn and position ourselves as a continent to see how we can use artificial intelligence. Technology to also help with virtual hearings. So, like I said, remote mediations and arbitration through Zoom. You can also use Microsoft Teams, and you can also use WebEx. As at now, I don't know how many people actually go to cases. So I know when it comes to arbitration, some people might have to go to, let's say, a hearing, they might have to be in a room and stuff. But in the case of mediation, you could do most of them online, unless the parties say, I don't want online, and so we have to meet in person. And so Zoom, like as we are having our conference, serve as a very important tool for us to use these platforms. Also, cloud computing is a technology that has really helped in AI, and it's usually applied for securing online case management and document sharing. So if for those who are not familiar with mediation, when you have mediation, you usually have to track your cases and stuff because sometimes there could be a court case. All those you might not use that in court, but it's good to know the progress of your mediation, how many cases you resolved, and how you can better yourself. And so you can use this cloud computing technology to help you just manage your case and also to share things with your clients. Sometimes you have to send the contracts for your client to share. And so this cloud computing technology is very good because it has end-to-end and encryption, which can protect your file. We also have the blockchain, which is a very important technology. What it does is it's a smart contract, it secures digital records and also prevent tamper-proof evidence. So you don't need so people, as we know, there's lots of things going on online where people can do different things to your data and stuff. And so this blockchain serves as a very secured platform for your stuff. And cybersecurity is also a technology that can help. What it does is it protects confidential information and ensure secure online proceedings. And so these are various ways that technology can transform alternative dispute resolution. So let's look at, I'm sure many of you might be asking yourself, does Africa really use dispute resolution? And they do. So I have a couple of countries in Africa that uses this resolution. When we take Egypt, for example, I read that Egypt does have e-filing or civil lawsuits. So they e-file their civil lawsuits online. Kenya to also help with the digital courts. Even Tanzania, they also have e-filing of civil cases online. And Tunisia, they actually have a national AI strategy that they're using now, and it's even going to get better. If we take Mauritius, for example, they have digital signature platform, they have DocuSign and so many things that you can use. So these are all technology that is really helping. And Nigeria, we have the e-filing of civil lawsuit, which is filing of civil lawsuits online. South Africa to also have smart drafting platform that they could use these AI platforms to draft their cases. So what is the state of alternative dispute resolution in Africa as of now? So alternative dispute resolution has experienced significant growth across Africa, driven by legal reforms, digital transformation, and increasing demand for faster, cost-effective, and accessible justice. Governments, judiciaries, and private institutions are adopting technology to modernize dispute resolution and support regional economic integration. I remembered initially I wanted to go to med school and I did chemistry, and I had the opportunity of volunteering in Ghana in the police system and seeing the prisons and how it actually operates. And that introduced me to alternative dispute resolution. And I chose my school, Pepperdine, because it was the best in the United States to study these things. And during my 1 year of studies, I realized that honestly, dispute resolution is really improving. Initially, you just have to go to litigation. We have lots of attorneys, and they were always encouraging courts and stuff. But honestly, if you can resolve your disputes through negotiation, mediation, and arbitration is always the best. And I know somebody might ask me, and I'm sure we've already had lots of discussions on what type of cases that could be resolved through ADR. It depends on the type of case. I'm mostly involved in mediation, and what I do is mostly divorce mediation, small claims, landlord to tenant disputes. And the most important thing that goes through all the time is that if you want to continue a relationship, alternative dispute resolution is always the best. So if you're divorcing your spouse, you have kids involved, you want to do mediation instead of going to litigation route where lots of emotions is at stake, lots of feelings, and things can get messy. You know, if you go to the judge is going to give you a verdict, and that's the end. But when you see a mediator, the mediator deals with all those emotional things that you're experiencing and is able to help you resolve your dispute amicably. So right now, Africa have really seen a significant boost, and it's always been there. It's always ADR has always been there. It's just now gotten a formal name, and we see lots of land disputes. And those days we had our forefathers or our godfathers who would sit people down to resolve their disputes. That is just the alternative resolution style. And so it's always been there, and Africa keeps improving in that style. So now that we know the state of dispute resolution, it's important to look at opportunities and strategies positioning. So we as Africa need to position ourselves. We all know what dispute resolution is, and we just need to position ourselves for the future. And so let's look at ways that we can position ourselves as a continent. It's important for us to leverage the African Continental Free Trade Area. I noticed that during the discussion today, that was mentioned. And so we need this to establish regional online dispute resolution platforms for cross-border commercial dispute. Sometimes you have dispute between two countries and stuff. And so using this African Continental Free Trade Area, it's a very important thing, or a way that African can position themselves. We also need to invest in digital infrastructures. So by expanding broadband connectivity, reliable electricity, very, very important. I know if I mention Nigeria, that would be biased, but we do need to improve reliable electricity and secure digital platform. I know that we are really trying as a continent, but if we invest in our digital infrastructures, it would really help us as a country. I'm seeing lots of young kids from Japan, little kids like 11 years old, 12 years old, and they are really utilizing these AI platforms. They are building robotics and stuff. So we as African youth, what are we doing? We need to see our leaders who are also on this call can see how we can invest in these infrastructures to help our continent as a whole. And we need to adapt to artificial intelligence. I know this is a very important topic because my mom is an illiterate. And so when it comes to anything about computer, she's always disturbing me. And I told her, Mom, you need to improve, you need to learn. So we as a whole need to adapt to artificial intelligence. And we need to change our mindset and not think that artificial intelligence is a bad thing. So I'm a very good advocate for that. It can be used wrongly, and there are lots of ways which I'm going to mention, but then we need to adapt to the drastic change of AI because AI is not waiting for anybody, so that we can improve our legal research, our document review, case management, and multilingual communication. So I've had mediations where people are from China, and then I only speak English. I'm from Ghana, I speak English, and that's what I actually mediate in. And so imagine I have to mediate with someone from China. Well, someone can say, get an interpreter. But if you have to get one, that means you have to pay for that interpreter. I've been using my AI model. Model has been communicating and translating from Chinese to English, from English to Chinese, and we've been having a smooth mediation. And so these are ways that we need to adapt to artificial intelligence. And we need to also build our human capacity by training judges, mediators, arbitrators, legal professionals in digital alternative dispute and AI. So as we are having this conference, so if we can have more things like this so that we can help build the human capacities. Learning doesn't stop when you have your master's degree, your PhD, or when you have the highest level of education. Learning is continuous. So every day we need to learn and improve our human capacity. We also need to strengthen our legal frameworks by harmonizing alternative dispute resolution legislation and developing ethical guidance for AI. So there was a case I had that an arbitrator actually went online. He had a case, he went online and then he put all the case and then all that he listened to into the AI. And then the AI gave him a verdict, and then he read that verdict and sent it as an award. So an arbitrator, the verdict that they gave is an award. It's called an award. But the United States usually their cases are worked on precedent. So past cases would predict the future ones. This arbitrator quoted cases that never existed because he just trusted the AI to and then reproduce. So we need to have ethical guidance here because AI is not always right. And if any of you have used AI platforms like Outlier, Handshake, you see that humans are the ones that feed this AI with information. And so if a human is feeding the AI with false information, you, the consumer, is going to get a false answer. So always when you use this AI for your legal framework, whether it is arbitration, mediation, or litigation, always cross-check and make sure that you are getting the right answer. Also, we need to promote regional collaboration among governments, universities, alternative dispute resolution institutions, and the private sector. So one thing that I would urge us as a whole is that we need to have, let's put ourselves out there. Let's have things like these that can help. And I don't know if we already have membership and stuff. So I'm part of the American Bar Association. I serve as the chair, and we have conferences like these almost every time. And we are all members of these. I'm sure we have things like this, but if we can promote regional collaboration, it would help us position ourselves to use AI effectively and to become better when it comes to using AI as a whole. So now we bring us to this very important question. What is actually the future of alternative dispute resolution? But in the next 2 years, in the next 3 years, 5 years, what is the future of alternative dispute resolution in Africa? Peter Drucker said, the best way to predict the future is to create it. So the best way to create the future is for you to create it. Africa's future in technology-enabled alternative resolution will depend not only on adapting to emerging technologies, but also on addressing the barriers that limit their effective implementation. By overcoming these challenges, the continent can build a dispute resolution system that is more efficient, accessible, and globally competitive. So, what are these strategic roadmaps that can actually help us for this future of ADR in Africa? So, to fully realize the potential of technology-enabled alternative dispute resolution, Africa must adopt a coordinated and forward-looking strategy built on these 4 priorities that I have grouped. The first is to strengthen digital infrastructures. So we need to expand reliable internet connectivity, digital platforms, and secure technological systems to ensure equitable access to online dispute resolution across urban and rural communities. I know we might argue that Africa as a whole, we do maybe just Accra, but then some part of the villages do not really have access to sometimes internet and stuff. But that's why we need to strengthen this infrastructure. Make sure that we make our continent as a whole to be looking good so that future leaders will not have to leave the country just to make it somewhere. So we need to really improve our digital infrastructures. I know it's easier said than done, but if we can really lobby this with our leaders to see how we shouldn't be getting light out unless there's like an actual issue. We should not be getting doomsday unless an actual issues, because you see, if you go to Europe, UK, America, you never have electricity off. You just don't have it. It's not done. And so we are in 2026. So we as Africa need to have that mindset and not just assume that everything is normal and that's how we are. We also need to modernize legal and institutional frameworks. So we need to develop harmonious laws, policies, and regulatory standards that recognize online dispute resolution, electronic, digital signatures, and responsible use of artificial intelligence. So sometimes it saddens my heart that sometimes we do not even have the tools. So there was a time that, this is completely off topic, but there was a time I was traveling from Ghana to the US, and just for us to pass through, they didn't have a digital boarding pass. The person was looking through paper to check out. You have to mention, they'll mention your name, Faith Williams, and they check it out. And it saddened my heart because I felt like, why don't we have that? Is it money? Is it infrastructures? What is really happening? But I know sometimes it all comes down to money. But if we can really look at institutional frameworks that can help us make ourselves better and really be on for artificial intelligence, it will really help Africa as a continent as a whole. We also need to build capacity in digital skills. So we need to invest in continuous training for mediators, arbitrators, judges, lawyers, and alternative dispute resolution institutions. So irrespective of our age, we should not say, oh, AI and stuff are for the Gen Zs. But it's for everybody because AI is evolving. And so we need to position ourselves strategically to learn all the time, irrespective of our age, so that we can effectively integrate emerging technology into dispute resolution practices. Like I already mentioned, we need to foster regional collaboration. And this is very, very important because we all, if you know, two heads are always better than one, and together we can hold each other and rise. So we need to leverage partnerships among governments, universities, alternative dispute resolution institutions, technology companies, and regional bodies such as the African Continental Free Trade Area to promote innovation, knowledge sharing, and cross-border disputes. This brings me to the end of my presentation. Thank you all for listening to me, and let's hope that together we can make Africa a better place and a better continent for all of us.
Thank you so much, Faith, for that excellent presentation and for helping us understand how we can utilize technology to and apply it to ADR practice across Africa. So the floor is open for questions, and there are a few questions in the chat, and then I think I'll open the floor with my own questions as well. So first of all, when it comes to technology, using technology, adopting technology in practice, and then specifically ADR practice, I think of the issue of confidentiality. So one of the characteristics of ADR practice or ADR mechanisms, most of them, especially mediation, is confidentiality. So I would like to ask, how can we balance the use of technology and then still maintain confidentiality of the process? And then I think the second arm of that question is AI tools or technological tools. When we use them, do they come in as third parties in the mediation process or in the ADR process generally? So I don't know if I should take all the questions or you just take them one after the other.
Okay, thank you for the question. I didn't get the second one, but I will talk about the first one. And like you said, it's very important when it comes to mediation, negotiation, or arbitration. Confidentiality is a very important tool. And so, as a mediator, I would say that when it comes to technology, that's why we have files that it does have like encryption. And even if you send out emails, you can have things that there has like a password that you could use. And if we move to the blockchain for an example, it helps let's say prevent sharing of the contracts or sharing of the resources and stuff. And so the parties would have access to their contract. So irrespective of having it online or in person, the contract will be distributed to both parties just to know what the outcome of the resolution is. But when it comes to online platforms, we have these we can, let's say, encrypt our files, where when it comes to sharing those data, it's not possible. And so I feel like these are ways that we can help. When it comes to AI, so AI, that's also one question I've been asking myself because I did software engineering. I know how to build apps. And so on the back end, when you build an app, on the back end, the app developer have access to everything. And so these AI platforms, even I ask myself the same question, what are we really giving this AI? And so I would say For example, when I'm having my mediations, I usually add the AI sometimes when necessary. And if it's very sensitive topic, in let's say during caucus, so I'm sure some people, those who are not familiar with caucus, is where you break the mediation and you speak to one party privately without the other person. With that, I don't add my AI tool because that is a private, confidential meeting where the party is going to share very personal thing that they don't even want their opposing, it could be their wife or the business partner to even know. So of course, AI should not be there because AI is a third party in the mediation. So before we have the mediation, I tell the party, my name is Faith Williams, I'm your mediator, and I have Modo. Modo is also my co-mediator, technically, because Modo is an AI also on the platform, and they both have to agree. So if they tell me, can you please not put Modo on, I don't put my AI. So the parties does have to agree to having this AI platform there if the AI is going to be there. If they decline having AI on the call, then you don't put the AI. So yes, AI is always a third party on the mediation because it's basically you see the name there and it's on the call and it's taking notes and it's listening to everything you are saying and stuff. And sometimes I've had some glitch where my AI would be talking as if I was the one talking. So sometimes it's weird, but yes, these are you have to make sure the parties agree to that. And so I don't know if I've answered your first question. What
Thank
of
you.
the second?
Yes,
Yes.
you answered both questions. Thank you.
Okay.
So there's a question in the chat from Edward. Edward says, should technology be driven by a national policy or by an ADR institution? Which would be most effective in Africa? National policy or ADR institution?
Sorry, I didn't get the question.
The question says, should technology be driven by a national policy or by an ADR institution? Which of them would be most effective in Africa?
I think national policies would be the best way because the ADR driven policy as a whole might just be a small quantity of people. But if it's a national policy, that could be good. So if our government can utilize AI, I don't know if right now we are utilizing AI in Ghana or in Africa as a whole, but if we can really increase our usage of this AI and stuff, sorry if I'm hearing a feedback, sorry. If we can really have, let's say, a government policy that encourages the use of AI platform, that would be good, and that can also help arbitrators immediately use those type of tools. Because when we look at the cost aspect, it might be more expensive if it's just an individual or a group of people, but if it's a government policy, that would be really good. And so if we can invest in that, I feel like Africa can go far as a whole. So yes.
Thank you so much. So the other question is, how can an arbiter who is not a lawyer use technology to keep abreast with the legal framework to settle matters?
If I heard your question well, it said, how can an
I
arbiter
take that again?
Yes, sorry, I don't know what's happening. I'm not hearing you quite well.
So we say, I think your microphone is down. So if you can lift up your voice a little bit, I think, let me see if I can have the,
No, it's on.
this is the,
Maybe it's my network.
okay, so this is the
Yeah, is
question.
it
Let me
better
read
now?
it for her. It said, how can an arbiter who is not a lawyer use technology to keep abreast with the legal framework to settle matters? So that's the question.
Okay, so I don't know if the person is familiar with arbitration, but arbitration, like I said, you write a verdict, which is an award. And as an arbitrator, you need to sometimes document those awards or the cases because sometimes the parties might reach out to you after a week or two and then they want to go to court. So mediation is confidential and cannot be brought to court. So whatever happens in mediation stays in mediation. You cannot call a mediator when you go to court. But sometimes arbitration, the arbitrator can give you an award and you can go to court and the people can be like, we want to, let's say, go to court and then fight this case, and the arbitrator can be called. So these technology tools can be used to, let's say, document instead of having series of papers. I've seen so many lawyers when I go to court, they have a full, huge briefcase. I'm not saying it's bad, but if you can just have a laptop or a tablet that you have all your case files on those softwares, I feel like that's more effective, and you really don't lose these files. So regardless of litigator or arbitrator, these platforms are good. I also have my mentor where I sat in an arbitration, and so because it's confidential, I will just highlight it. But it was a case of a police officer who used the police software here in LA City Attorney Office to run a test on her ex-boyfriend's girlfriend. And so that was illegal. You cannot do that. And so the police union was sacking her from the job. And so I sat through the arbitration, and the arbitrator gave the award. And so he agreed that she should be sacked from her job. And it means a lot if a police officer loses their job, that's losing the integrity. You might never get a job anywhere. And so she had to appeal the case. And I was the one that documented all the folders online. And we didn't really, my arbitrator is in his 60s. And so he likes writing things down and stuff. It's just so happened that he misplaced some of the papers. That was bad. It usually doesn't happen, but that can happen. And so when he lost the paper, I realized that I had these documents in my case file online. So I showed it to him, and he was really happy. So I'm just saying that whether you're an arbitrator, technology is really good. It can help you track your case file, track your cases, even your schedule. You can use technology to track all your schedule and what cases you have and stuff. So these are ways that it can help even as an arbitrator or a lawyer.
Okay,
And
thank you so
also,
much.
yes, and also some lawyers are also arbitrators. So we have mediators that are mediators, arbitrators, and lawyers, and they can wear any hat at any time. And so I've been having a case where I have to arbitrate, and then I have to mediate. The parties will be like, "Can we mediate first?" So the parties can tell you as an arbitrator, "Can you mediate rather?" And then you can wear the mediation hat and mediate. And so you can switch between any if you are qualified for that.
Thank
So
you so much. I know you have limited time, but I don't know if we can take a few more questions. So,
yes,
okay, thank you. So the next question says, how do we build an African ADR and AJS jurisprudence? I don't know what that is. That simultaneously protects indigenous knowledge, governs digital transactions, resolves smart contracts and cryptocurrency disputes, and leverages emerging technologies without reproducing external legal dependency.
okay, that's a big question. What I would say, it's a really big question, and I know it's really not going to happen just today, but I would say that we are the future leaders, all of us on this call. We are the future leaders, and we are the ones that can build these. Sometimes our leaders don't even know these tools. So you said, how can we build? I said it starts with us. And so all we need to do is we as a whole need to start from somewhere. I know it's very, very vague. I really don't have the answer. And so if we start from somewhere as individuals, then we can build these legal frameworks that can help people. I would also say that AI is still evolving, and so it's not very much lot of studies are still going into it and how it's actually being used. I've seen so many diverse opinions about it. Some people think it's bad and should not be used because of data sharing and because of lots of frauds and lots of things that could actually affect people negatively. And so I feel like if we do more studies into this as a whole, then we can develop smart devices that can help us as a whole. So I know I did not really answer your question. If somebody else can answer this question, if you have any answer, that would be great. But I think we just need to start from somewhere and we can move on that. So yes.
Thank you so much. So there's also someone that is interested in your AI model is asking if you can throw more light on your AI model, the
Okay,
one that
so
you use for your mediation.
yes, we can even talk more privately, but they have lots of software tools that can help you create your own AI model. And so if you don't really know how to build from scratch, how to do a lot of things from scratch, I would share a couple of things in the WhatsApp group. I believe everybody is in that group. And so we can use those tools to build our AI models and stuff. And also you can learn how AI works as a whole, and you don't really need to use a template to build it. You can build it yourself from scratch. And I'll also send you a couple of things in the group on how to learn how to use AI and stuff. And if you're not familiar with some of them, you can just start using ChatGPT, you can start using Water AI, start using some of those tools just to have a feel of what it is and how it works. But I will share those resources in the group chat. I think that will be more effective so that you can look at that.
Thank you so much. So one final question from Ngozi. Her hand has been up, and that will be the last question. So Ngozi, you have the phone. Please straight to the question, and then we'll conclude.
Okay. Thank you, Faith. With respect to the use of AI, Sewese actually spoke my mind on confidentiality. Reason being, but you have answered that, so I will not overflog that. Now, in addition to what you said about lawyers, somebody asked a question with respect to lawyers that he is not a lawyer. So there are AI tools that lawyers use. And it's not only restricted to lawyers. It's just for you to go all out there, check online. If you have friends that are lawyers, you can, but of course, the way you use your internet to look for every other thing that you want to look for, you can use that as well to check on fast, to read on anything law. Even you can go further to use do some certifications, online certifications on legal knowledge, to have legal knowledge of whatever you want to do. So if you are dealing on a workplace mediation or workplace dispute, you have to go through your employment law, labor law, just to have a grasp of what you are going into. So they are all out there. Then when you were talking about the back end, what came to my mind, I'm a Nigerian, the Data Protection Act. So each data subject, and your clients are the data subjects, they have rights, and those rights needs to be protected. So who is the data processor? So that's one thing with AI, because you ask yourself, will the data of your clients be protected? How protected are your clients? I like the fact that you said that you always tell them that you have a third party and they have to consent to that. There should be mutual consent in all of this, but are they still very much protected as well? So that such a client can also, question in it, even with the consent, because sometimes we consent because we don't have options at the moment. But you, now that is the mediator, should make extra effort to make sure that they are right, so that at the end of the day, the Data Protection Act will not be held against you as well, because you as a data processor should manage those rights, manage those information, because there are some personal, I think it's PIDs, personal information details, that even those ones are also very critical. And also know what you put out there. Don't bring in real names, pseudonyms can help here. Then I also like the fact that you mentioned this was the agreement between the two erudite scholars that have been mentioning over time, the two professors, where you discuss about from MedApp to AppMed, that's combination of dispute resolution pathways. You can blend the two to achieve a good result. Then with the harmonized legislation, my own thoughts is that we're all canvassing for originality. We want something that is African, but let's also know that for all the Africanness that we want, just like Professor Olaji Babajide said, most of our laws are transplanted because of the common law and all those the colonization that happened. How do we now, for us to have that holistic, original African laws, it's now for our policymakers and our legislators to now, the states, it has to be, it's now intra-states within Africa, to now have a harmonized dispute resolution. I wouldn't know if it is attainable because of our different legislation and legal traditions, our legal backgrounds. But at least we'll have something that, okay, this is Africa. That whatever we are going to do, when you look at it, you will see that connection that yes, we share some kind of a common tradition, though not too common, but there are things that bind us together as Africa. So I think on that light, harmonized legislation is something that we'll keep talking about and bringing, our contributions to, and hopefully we'll get to that point. Thank you for a wonderful presentation, Faith Williams. Thank you very much. Yeah. So my own is not a question, it's more like, adding to what you have said. Yeah, thank you.
Yes, thank you so much. Sorry, thank you so much, Ngozi, for the wonderful contribution, and I really appreciate that. And I believe everybody did take away a lot of things from what you added to the presentation. So thank you for that.
So thank you so much, Mrs. Faith, for having us. Thank you for creating time to be here. Thank you for your patience, and we'll definitely be reaching out to you even after here, because it's really an interesting area. Thank you so much.
Thank you, Savannah. So I'm gonna write my email, and I don't mind sharing my phone number. So I know some people preferred me to add the links in the group. What I'm gonna do is I'm gonna share my link and then the email and everything, and then my LinkedIn profile, and I'm gonna create a whole PDF for all these various things that you could use to learn, and I will probably send it to Isaac, and Isaac can share with anybody from there. I believe he has access to everybody's email address, and so I think that will be easier.
Yeah. So thank you so much. Thank you very much. We appreciate it. So we've come to the end of this session, and we'll be taking a break, about 10 minutes break, before we'll resume to commence the next session. So you can get up, stretch, take a cup of tea or juice, just relax a little bit, and we'll be back shortly. Thank you so much. Mr. Isaac? Okay.
Yes, thank you. So we are on break. Yes, thank you so much. We'll meet in the next 10 minutes. So it's now 1:54 p.m. in Ghana. So 1:26, we'll be back. We are getting closer to the end of the conference. So stretch, get some water or tea or coffee, and come back. Thank you.
Yes, and for those asking for the group link, or for the, yes, the link has been pasted in the chat, so you can join the WhatsApp group. Thank you.
All right. Welcome back, everyone. I hope you can hear me. Yes, good afternoon once again. I hope these individuals are online. Nicolina Na Yeye Adumwa, Ngozi Miriam Arinze, and Dr. Deepika Sani. If you are online, please put on your videos.
Hi, Isaac.
Yes, thank you. Great to have you. If you can put on your video, we are going to put your panel into the spotlight. So your panel session is next.
Basically, I am with the very limited bandwidth, but it will take 15 minutes to switch on the camera, and I'll be there. I'll do it while on the panel.
Okay, right.
Yeah.
Okay, so can you hear me?
Yes, I can hear you.
All right, so you can start by letting them introduce. Thank you.
All right, thank you so much, everyone, and welcome back from the break. So our next session is titled ADR as a Tool for Economic Growth, Peace and Sustainable Development in Africa. And on this panel session, we have Ngozi Arinze, we have Nicolina Adom and Dr. Deepika. They'll be taking us through this session, and my humble self and Mr. Isaac will be moderating. I don't know if Dr. Deepika is still on the call. It looks like she has dropped off.
Yes, I am on the call itself. Thank you very much.
Oh. All right, so welcome.
Thank you very much for your time.
All right, thank you. So we'll just go ahead and begin the session. So I'd like to invite, in no particular order, but we'll begin with Nicolina. Just briefly tell us about yourself, and then we'll look at ADR as a legal dispute resolution mechanism. So, or legal or dispute resolution mechanism, rather. So when people think of ADR, they often see it as a legal or dispute resolution mechanism. So how we're looking at the connection between ADR, economic growth, and sustainable development.
Sorry.
To policy makers and business leaders.
So if you can hear me, can you hear me? Hello, can you hear me? Yes, if you can hear me, their topic is on. Yes, their topic is on ADR as a tool for economic growth, peace, and sustainable development in Africa.
Yes, that's what I said.
Okay, all right, thank you.
Thank you so much. So over to you, Madam Nicolina.
Okay,
I don't know if yes.
Okay, can I be heard?
Yes, please.
Good afternoon, everybody, and thanks, Isaac, for bringing me in, and to yourself as a COC Okay. Being a moderator for this afternoon. My name is Nicolina Nayeye Adumwa, as you rightly said. I am a certified mediator. Of course, I trained from Isaac's institution. I am professionally a marketer and a chartered insurer. I'm also involved in projects as one of my expertise. I'm involved in mediation at church and more especially with the work I do as an insurance regulator. I'm also the president of the Chartered Insurance Ladies Association, Ghana, and also the vice president for the African Insurance Women Association in charge of West Africa. Now, looking at the topic at hand, we're talking about economic development and using ADR as a tool to enhance this economic development for Africa. And then we're also talking about building peace, and we're talking about sustainable development. These are very critical to the soundness and full development of any association, country, and for that matter, Africa. From yesterday, we have been talking about ADR. And for me, when you talk about economic growth, you're talking about production of goods and services that will inure to the growth of a country, that will provide increase in our GDP. You're talking about high employment. You're talking about increased income for our people. You're talking about improving living standards of our people. And you're talking about even attracting investment to our continent, our country. Now, Ghana can boast of about 35 million people. And then you're talking about Africa in the millions. And so long as there are institutions, so long as there are people, so long as there are communities, there will be disputes. So long as there are businesses that will ensure that infrastructure of a country is built and there's growth and development, there will be disputes. Now, if there are this, so be it, then how do we use ADR, or what will be the role that ADR will play in ensuring that we have peace, if we so want, and then there will be economic development. Now, so if once again, we just spoke about technology, using technology for our work as ADR and mediators. And so you will realize that it becomes a very important tool. We have spoken extensively from yesterday, even this morning, about policy frameworks. Now, in African continent, we have also established the fact that we had a system where our elders and traditionally were able to resolve disputes among ourselves even before now. We are only making it formidable, and that is where I see we taking ADR. Now, for us to be able to grow our economy, we need to reduce poverty. And how can we reduce poverty when there are disputes between businesses? When the infrastructure that had to be built, you have people having disputes among themselves. So it becomes very difficult. And that is why, for me, this session is very, very critical. Now, what are we looking at here? We are looking at ADR as the tool. So I will say that it is important that the tools of ADR be trained on, as everybody has said, so that we can improve and we can promote economic investments. I also want to espouse that we need to think about it as a way of reducing the cost of litigation and time of litigating. Now think about I give a scenario of two companies that are supposed to construct a road to a major town within Ghana, Africa, where you have food growth, and there's disputes. Everything is taught. You can attest to the fact that now there will be no continuity of the work unless this litigation is settled or this dispute is settled. And so ADR forms a very critical tool in ensuring that quickly and as early as possible with cost efficiency, overcome this dispute, settle it amicably, and then projects or construction can go on. Again, ADR as a tool is used to enhance business relationship. In that same scenario, and when I talk about, I see ADR and I look at it in the frame of peace, where the good book talks about be at peace with all men. So long as there is business, there will be disputes. We will have disagreements. But building strong relationship in order to enhance economic growth is important because if we establish good ADR systems and the laws are well put in place, we will in no time settle disputes that arises, and we will be able to have good relationship to continue with businesses. Support SMEs, small scale businesses, and entrepreneurship. If a business owner knows that when I'm in trouble with another business owner, and we have disagreements, and I can use the ADR system to establish amicably solution, I think that businesses will thrive and the economics will grow. And so ADR is very critical. If this is my introduction, I will say that this is the way I'm looking at it, ensuring that there's business continuity, ensuring that there's cost effectiveness, reducing cost of litigation, and also promoting investment. When it comes to peace, again, you would want to have peace, but somebody might not want to have peace. What do? The ADR system provides the opportunity for us to come to the table, especially when it comes to mediation, for us to talk and to dialogue and to put the cards on the table. But most importantly, since we're talking about business, we need to establish the rules. The clauses that must be in the contract must be in the contracts. We're talking about AfCFTA, where there are no clear-cut structures in settling disputes in the framework of AfCFTA. And thus, we have spoke about it extensively, and I want to support the call for us to look at what's already existing. WTO has it. There are international frameworks and blocks that we can take best practices to help us. All these things will inure to the tools. Now there will be encouragement for dialogue. Once we are calling for peace, we need to be able to sit to jaw, not to war. By all means, there will be disagreements. But when we sit to dialogue, it gives everybody opportunity to say their minds, to say how they feel. We can attest to how I have offended somebody and how I have not attended to my portion of a business agreement. And that's what brings peace. We're talking about peace. And also, ADR as a tool can be used to reduce tension among business partners. Now, reduce violence, reduce tension. When we come to the table and you have a mediator, neutral, mediating our cases, as per training and skills development, you are able to weather the storms. You are able to calm tension. You are able to let everybody feel important and wanted and relevant in the case at hand that we are disputing. You are able to establish a framework that tells everybody that, yes, you have a case, but can we look at it dispassionately in a different eye, with a different mind and a different eyesight. You are able to help promote social cohesion, because if we have communities that are and values must be espoused, ADR helps strengthen this trust and values. So for me, bridging the gap between businessmen and, for that matter, looking at Africa, we must also remember that Africans are not trading among themselves alone. And so in as much as we want to attract foreign investors and have foreigners come invest in our country, we must do everything within our power to make sure that there's a good governance framework. We must make sure that there is cohesion. We must make sure that there is no violence. We must make sure that we are promoting peace among ourselves. Talk about sustainability. It's important that we know that the G16 talked about peace, justice, and strong institutions. Now, I will engage all of us for want of time to go and read the SG16, SG7, SG17, and SG8. This talks about ensuring that there is peace in every business agreement. This ensures justice and fair treatment. It also talks about strong institutions. And when we talk about strong institutions, as a management practitioner, I would say no strategy can work effectively without structures. And so some of the structures we want to build firmly will be institutional. You look at regulatory frameworks. I work in the insurance space. If you don't have strong regulations, anybody at all can come within the space and think they can do what they like. AfCFTA is there to guide and to help us economically grow as Africans. But then there must be strong institutions to call the shot to say, look, you cannot do this within this framework. If you're coming in as a business partner, these are the rules of the game and you must adhere to. So strong institutions are very vital as part of the ADR frameworks to ensure that people's rights are not trampled upon, that there's fair treatment, and there is peace and lack of violence. I think on this note, I will pause. And if I had to come back, I'll continue. Thank you very much.
Thank you so very much. We'll now move to Ngozi Arinze for our perspectives on the topic of discussion, ADR as a tool for economic growth, peace, and sustainable development.
Okay, I'm Ngozi Arinze, a lawyer, a certified mediator, and I also hold a postgraduate in education. Because of my love for children, child protection, safeguarding, my expertise is on family, human rights, child protection, like I said, and also gender-related matters. In all of this, I bring mediation to the table in all these aspects of my profession. So today we are discussing about economic peace and sustainability. I'm going to start with peace. I'm going to reverse a bit, starting with peace. Peace means that there is no conflict. That is, we're in a situation where everything is in place, no conflicts, no issues. So peace brings about stability, and stability brings about investors' confidence. And when there is investors' confidence, there is investment. And when there is investment, there is growth. And when there is growth that is sustained for a long period of time, we now come to what we can refer to as sustainable development. Now, with respect to peace, as long as humans interface and interact, there will be issues. So within the perspective of business or commercial purposes, an investor would look at if my contract, if the contract I'm entering into with the other party, if it's enforceable, if it can be enforceable, and also whether there are dispute resolution mechanisms, because for every investor, the mindset is not to go halfway. The mindset is to continue the business and also to make profits. So, but they also know that at a point in time, there might be issues arising from the contract. So how best those issues will be resolved is what will help attract them. Opportunities alone do not attract investors. They are looking at a framework or an ecosystem where they know that their investment is safe. On that note, peace, in trying to build peace, the investors first of all, they have both parties will have trust, have confidence in each other that they are going to obey the written contracts, obey the pars sonta servanda, each part of the contract. So if both of them have agreed and they have appended their signature, they've agreed that they are going to maintain the status quo. In maintaining the status quo now, the investor now has the mindset to now do the investment. With respect to investment, the investor is also looking at how do this framework, the ADR, respect to alternative dispute resolution, what the alternative dispute resolution does, how best it resolves commercial disputes, is that one, the feelings of both parties are usually validated, and like my sister earlier mentioned, the operational cost is also there, because at any time there is disruption caused by issues, disputes arising from contract, operational cost. The going to court is among litigation costs among the operational cost, and that an investor wouldn't want. So they want an easier avenue where disputes are resolved and they move ahead with the contract and they move ahead with the investment. So coming to investment, like I mentioned, when there is peace, there is investment. An investor has now the confidence that yes, if at any time we have issues, that they are because of litigation, everybody's trying to avoid litigation. There is a well-structured alternative dispute resolution mechanism that will help to bring back the two parties to function in that very contract they earlier addressed. Then sustainability has to do with that this growth now has come to be. When there is more investment, investment opens other forms of benefits, even to the other citizens. The employment rate goes high. You see that there is transfer of funds, transfer of wealth, and also with respect to the human development as well. And that sustainability will only come to be when there is peace. Remember, in all of this, there are different sectors where alternative dispute resolution can work. It can work in commercial, it can work with issues that has to do with climate, at the point where the company and the communities are having issues. So if the peace that usually comes through, is from below to the top, that's from bottom to the top. So if there is peace, if there is no violence and everything is in status quo, the investor already knows that, okay, I can make my investment here and that my investment will grow. So that sustainability will now come when there is continuous investment. And in that light, once there is sustainable development, then the economic benefits from that investment would mature. On that light, I think I've made my own submission that peace brings about stability, and we need stability. An investor needs the confidence of an investor is built on whether, one, there is stability, whether on issues that borders with conflict that will arise from the contract, whether those issues can be handled within a limited time space, because time is very, very, very critical when it comes, because there are some contracts that are time bound. So no investor would want to invest in places, like I said, opportunities alone do not attract investors. There are other things that an investor looks out for. They're also looking at the legal system, they're looking at the ADR, which is now commonly used, commonly embraced by investors, because they know that ADR is faster, ADR validates their feelings, ADR gives them also not only litigation looks at the legal issues, but ADR looks not just treating the issues at hand, but the underlying issues, underlying interests of the parties, and also brings them to constructive dialogue that will even make the both parties to see if there are potentials. That's one beautiful thing about engagement of ADR, alternative dispute resolution mechanisms, because during the dispute resolution, the parties might even see what is hidden, because they are now, there's effective communication, both of them can now talk. They might see what they ab initio did not even see, that there are potentials. But in litigation, just the the judge, as the umpires, gives the verdict. And like I've forgotten the name, but there's this popular quote by a Nigerian lawyer that is that once a judgment is given by a judge, that is when the real conflict starts. Litigation brings about bitterness, but ADR is all about how do we unify these two parties. Yes, there will be issues. Issues will arise because we are humans. Because maybe one party will fail to do the other. It is its own part of the bargain. But how do we make sure that the purpose, the primary purpose of this contract or this commercial purpose is actualized? So ADR goes that far to not just handle the issue at hand, but looks at the underlying interest of parties and even, facilitates towards them bringing out or fine-tuning or finding out the hidden opportunities that are very much inside that contract that they are in already. Thank you. So sustainable development will come through when the investments and all that has happened.
Thank you so much, Madam Ngozi. So we'll move now to Dr. Deepka. Dr. Deepka, you can hear me?
Yes, yes, very well, I can hear you.
Yes. Thank you. So let's have your perspective on the topic of discussion.
Shall I start?
Yes, please. You have the floor.
All right, just a second. Distinguished guests, respected delegates, ladies and gentlemen, my name is Dr. Advocate Deepika Saini and I am from India. It is my honor to address this wonderful and intellectual gathering on the subject that holds immense potential for Africa's future, alternate dispute resolution, as a tool for economic growth, peace, and sustainable development. Thank you, Africa Center for Collaborative Dispute Resolution, for this wonderful ADR Conference 2026. Thank you very much. So in today's interconnected world, conflicts are inevitable. They may arise between individuals, communities, businesses, governments, and nations. However, the way we manage these conflicts determines the strength and the progress of our societies. This is where ADR becomes a powerful instrument for transformation. Alternate dispute resolution, including mediation, negotiation, conciliation, and arbitration, provide peaceful, efficient, and collaborative mechanism to resolve dispute outside traditional litigation. ADR is not only a legal process, it is a culture of dialogue, understanding, and cooperation. So since the topic is, which is on the economic growth, peace, and sustainable development, I would like to give one example. Uh, Recently, I have received one of the case saying that I need a divorce from my husband, and you all would be surprised to know the reason. The grounds for divorce was that my husband has not wished me birthday at 12 a.m. So now I need a divorce from him. So I believe if this case would have gone to the litigation perspective, this would have taken n number of years to get it resolved. But yes, through mediation, we have tried to resolve this case in 3 to 4 sittings. That's how the mediation, the alternate dispute resolution mechanism, is actually creating peace so that the matters which are actually required to be in the court should go to the court, and the rest of the funneling to be done wherein it is not necessary to be in the court can be resolved across the table. So that's what I would like to start with one of the example which I have recently received. So Africa is obviously a continent of enormous opportunities with its growing economies, young population, natural resources, and increasing global partnerships. Africa has the potential to become a major contributor to the global development. However, sustainable growth requires stability, trust, and peaceful environment. So one of the greatest contribution of ADR is its ability to support the economic growth. Investors and businesses seek environment where disputes can be resolved quickly, fairly, and efficiently. Lengthy legal battles can delay the projects, increase cost, and discourage investment. So, ADR offers a faster and more flexible approach, helping businesses maintain relationships and continue economic activities. For example, if we have to talk about the commercial mediation and arbitration, which can actually support cross border trade by creating confidence among the investors and entrepreneurs. As Africa strengthens regional cooperation and trade initiative, ADR can become a foundation for building trust between countries, companies, and economies. ADR is also playing an important role in promoting peace and social harmony. Many conflicts begin with misunderstandings, lack of communication, or unresolved grievances. Mediation creates a safe space where parties can listen, communicate, and find a mutually acceptable solution. So, across African communities, traditional dispute resolution practices have been long emphasized reconciliation, community participation, and the restoration. Modern ADR builds upon these values by combining cultural wisdom with contemporary legal frameworks. This makes ADR a tool that is not only a practical but also deeply connected with African traditions. Furthermore, ADR contributes to sustainable development. Sustainable development is not only about economic progress, it is also about social justice, inclusion, and the peaceful societies. And when communities have access to the effective dispute resolution mechanism, they are better equipped to address challenges related to land, environment, resources, business, and human relationship. To maximize the potential of ADR in Africa, we must focus on several key areas. First, awareness and education. ADR should be introduced widely in universities, professional institutions, and communities so that people can understand conflict resolution as a positive approach rather than the confrontation. Second point is capacity building. We require to need more and more trained mediators, negotiators, and ADR professionals who can actually handle the complex dispute with competence and integrity. And third and the last is the strong institutional support. Government, business, and international organization must collab to strengthen work and make justice more accessible to all. So, ladies and gentlemen, the future of Africa depends not only the resources and innovation, but also on our ability to build trust and resolve differences peacefully. ADR gives us a pathway from conflict to cooperation, from disagreement to understanding, and from uncertainty to sustainable growth. Let us recognize ADR not merely as an alternative to courts, but as a strategic tools for economic development, peace building, and strong Africa. Thank you very much, everyone, for listening me so patiently. Thank you very much.
Thank you, Dr. Deepka. Thank you so much. So I'll go back to Nicolina. From listening to all of you, we've established the fact that there's a connection between ADR and economic growth, peace, and sustainable development. So having laid that foundation, let's look at, we've even gone in, like Dr. Deepka has gone ahead to even make recommendations of how we can sustain ADR as a tool for peace, economic growth, and sustainable development. So let's look at challenges, barriers to achieving this? What are those challenges, barriers that can prevent this ADR from being utilized as a tool for economic growth, peace, and sustainable development?
Okay, thank you very much. And thanks to my sisters for their insightful contribution. Some of the challenges I would say will be cultural nuances. In African settings, we have a way, for instance, culturally in Ghana, we say that you don't look into the face of the elderly when they are talking to you. You don't use your left when the elderly is talking to you. When you have an issue with an elderly person, you have to calm down. You have to rise when there's an elderly person around you. So all these things affect the way we think and we look at things, even when it comes to business. I remember I was in once upon a time, I was in a company, and this is a lady from another country. And though we were in the meeting before she came in, she walked in, she expected the junior ones to stand up and to greet her and to give her the chair to sit. And this became an issue that I had to come mediate way back to settle. So you see, culturally, the way we look at things are different because we come from different environments, even from our homes. The way we settle things, comes differently. Some would, when their issue, will want to take a back seat. Some wouldn't want to engage. Some will want to shout on top of their voice. Some will maintain a stand and not bow and not understand dialogue and will not appreciate any dialogue. Some say, this is my stand and that is it. Now, these are some of the challenges because when we come to the mediation table or when it comes to the ADR table, everybody should be given the opportunity and everybody needs to have the confidence that my side will be heard. So it becomes a barrier when one party thinks that, no, I am in the right and I'm not listening. Okay. Now, again, the awareness of the benefits of ADR, it's also one thing that becomes a challenge. Of course, you cannot say that ADR is free because it's not free. And so if people are so poor that they can't even afford even taking a car to where a mediation center is, that is where we have online, so we can use our phones, okay? But how many people also have that capacity to say that, okay, I'm sitting in my house, you are somewhere, somebody is in another country or another district or another region, let us buy credits and then go on this. Now, one other challenge is that understanding and people's perception and mindsets becomes a barrier. And the challenge is that, what is the issue at stake? Do we all appreciate where the flaws are with the issues of disputes? Do we appreciate that somebody might not have done something right? Do we all appreciate that we didn't set the rules right and now we want to remedy the situation? These are things that forms barriers. Language is an issue. Also, we're talking about Africa. And so we all don't speak English. We have Francophones, we have Anglophones. Understanding of issues are sometimes different. And so coming to the table, we need to be able to go around all these challenges to be able to appreciate. Now, one challenge I see also with mediation sometimes and arbitration is that the mediators themselves sometimes have challenge with appreciating both sides. And so if you're not very skillful, you tend to be biased. So you have to be very careful. And that is when it calls for more skillful skills training like we are doing now to be able to overcome some of these barriers and challenges. I submit.
Thank you so much. Madam Ngozi, you have your intervention on that as well.
Okay, I think my two sisters have actually done a whole lot of justice to that, but there is something that came to my mind, and during all that, if we actually want to have ADR work, we have to institutionalize ADR. Yes, in Nigeria, I believe maybe across Africa, there are court annexed, like multi-door courthouse like we have in Nigeria, most of the states, if not all states in Nigeria, so that the courts will even come to that understanding, the judiciary will come to that understanding that there are some cases that are more tailored to alternative dispute resolution. And why we even call it, when I was doing my findings, why do we even call it, in my own perspective or reflection, we call it alternative because we think it's secondary. There are times it is primary. It is that primary, or like it's more like the primary infrastructure that deals with a particular case. Like I mentioned earlier during my first submission, what a judge, a popular quote from a Nigerian, that when the judge gives judgment, that is when the real conflict starts. So there are cases that even the judgment of a court initiates the real conflict, and you more like either you go for appeal, or you will see that there was one time during one of our trainings, one of the facilitators said there is this particular case he handled. It was even a Supreme Court judgment that was not even acceptable to the both parties, that they had to go through the route of mediation to settle that, because it had to do with transboundary. It's a common market, a common market shared by both villages. They now have to bring part of this village name and part of the other village name, and now had a unified name that reflected their community heritage, their own perspective. That was when the real
designed exactly for people like you, professionals over 40 with untrained communication skills. Like these are reading books that are not for 20, reading all the it doesn't train.
Can you? Yes, thank you very much. So what I'm saying is that ADR should be embedded in our justice system, and there is also the need for judges to be trained, policymakers to be trained, and also to catch them young. I mentioned yesterday about ADR going through our early childhood education. It gives that culture. As children get to learn all this, it becomes a culture for them, so that the younger generations that are coming after us. So what are the challenges? I remember that it's now the challenges that we are dealing with. The challenges that we have, just like my two sisters have earlier mentioned, now we have that challenge of capacity. Even we, the ADR, will have to go through this capacity training so that we even relearn, learn the skills that are very essential for us to become professional ADR experts. And also, we are also looking at that cultural bias, which was also mentioned, that people's perception, especially with respect to the female gender, where they are not even allowed to talk. Culture demands that they are to be seen and not heard. So that's also the personal bias, and the cultural bias is also a key factor. It's also a challenge. And also digitalization of ADR, that's the ODR. Yes, we now have ODR, we have virtual hearings and all that, and we can do all we can within the technology space, but yet there are still some people in the underserved communities that don't even have access to internet or stable internet. It's also a challenge with respect to doing, because online dispute resolution brings a whole lot of benefit to the table. We talk about flexibility for women professionals. It helps them to be able to navigate the work-life balance that they need in order to maintain the home front and the workspace. And another challenge also could be our universities. I know, I think it cuts across now. In the schools, in the universities, you have ADR clinics and all that, and also up to law school for those that are lawyers. But there are still some, if you are not doing law courses, I don't think it cuts across. So it's something that should now be seen to be appreciated by all. I say when we have undergraduates who will champion this course, not just from the at the formal space, but also taking it down to the villages and communities where real issues, real life issues happen. is also a part of it. The capacity building goes beyond from informal to formal, because when we talk about peace building starts from the home. It starts when a mother binds the family together, the children respect parents. It starts when two communities decide, okay, we are not going into war. So you see that it's from that everyday peace that brings about that brings about stability, that brings about sustainable development. So these challenges revolve around appreciation of what alternative dispute resolution can do. My last submission would be alternative dispute resolution is African. I align with that school of thought. Our appreciation, we have to reevaluate how well our forefathers used that as against how we are doing that now. Once we are able to get that knowledge that our forefathers had, and they were able to treat many cases, including criminal matters, yes, then when there is no adversarial system, even during the adversarial, but they decided to do the ADR way, they were able to even deal on criminal, like petty, like issues of theft and all that. They were able to handle that. If we come to that consciousness that they were able to do this through the alternative dispute resolution, mediation, negotiation, conciliation, and all that, once we come to that understanding, we will now be able, that will give us the platform to be able to arrest any challenge, knowing fully well the benefits that comes with alternative dispute resolution, which we have outlined. It brings about social cohesion, it brings about peace building, it brings about economic development, and more so, Africa, like the Ubuntu, the South African Ubuntu philosophy. I am because we are because I am. Remember, in all of this, our brotherhood still stands as Africa. And in order to maintain that brotherhood, we should look for the most or the less strife means of dispute resolution. And that is what, in most cases, ADR brings to the table. So even with the challenges that I have pointed and my sisters have pointed, we have the willpower to arrest those challenges because of the ultimate goal that is embedded in the African alternative, or permit me to say, African dispute resolution. Thank you very much.
Thank you so very much. So as we try to round up for this question to all of the panelists, beginning from Dr. Deepa. So we're looking long term now, and we're looking at across Africa, we continue to experience a lot of political tensions, insecurities, communal conflicts, and all of that. So how can ADR be used as a tool to contribute to long-term peace building? And if you are going to recommend, what will be that one thing or important action that Africa can take within the next 5 years, possibly, to position ADR as a driver of economic growth, peace, and sustainable development? So I'll begin with Dr. Deepa.
If possible, can you just repeat the question once again? Because I lost the voice in between. Thank you very much.
Okay, thank you. Can you hear me clearly now?
Yes, absolutely.
All right, thank you. So I said we're looking long term. Across Africa, we see that African communities experience a lot of communal conflicts, political tensions, insecurities, and all of those issues. So how can we position ADR as a tool for long-term peace and sustainable development? And then the second arm of the question is, what's that significant action that we can take as Africans, maybe within the next 5 years, to position ADR as a driver of economic growth, peace, and sustainable development?
Thank you very much for the question. See, if I have to recollect the presentation when I started, I gave a very good example, which will actually shows that how people are moving towards the litigation wherever even it is not necessary. So when one of my clients approached me for for saying that I need a divorce from my husband. And me as a lawyer have asked her that what is actually the dispute? What are the grounds that we have to put to file this case? There was a very small issue that my husband has not wished me a birthday at 12 a.m. So I have nothing to post on social media. So my friends are going to make a mock of me. So this kind of dispute has approached to me, right? So if I am a lawyer, I would have n number of sections I know that I can ask her to go with litigation perspective. And it would have taken, I believe, 10 or 12 years to be in the litigation. However, when I speak with her with respect to mediation, saying that maybe there could be, if you are very much keen about 12 a.m. celebration, but your husband is coming from the different background altogether. He's coming from the different family, different culture. So for them, it would not be very much fascinating. So what we have done is that we have tried to make them, and try to bridge their emotional unavailability, which she was feeling. So we try to make them come to the common resolution, and hopefully in 3 sittings we have make them together. Now they are happily married couple. So the case, which could have taken 10 years or 12 years, and God forbid n number of years we can call it, have resolved in 3 sittings of mediation, that too in a 1 month. So I believe through matrimony, especially in matrimonial matters wherein the emotional quotient is quite high, we need to treat these matters very sensitively in terms of ADR. Number 2, there are matters with respect to which are check bouncing matters. What I have seen is that the matter which are check bounced, generally the first approach of the companies is to make these matters to litigation in the first instance. But if we move it towards the ADR, can't we ask them what was the reason that this payment has been bounced? Can't we speak with them in a manner that this can be resolved? And I'm sure when you put the communication forward, when you put the confidence forward, people would love to make your payment on first priority, because you have not, give them an option of legal, but you have given them the option of communication. And I believe where there is a communication, most of the matters can be resolved. So these are the 2 examples that I really wanted to quote. And I would like to say that peace can start from us itself, number 1. And number 2, you said recommendation for Africa in terms of the ADR. So I believe Africa is growing so fast in terms of ADR, because me myself is also working with many of the professionals in Africa, and I have realized I have so much to gain a knowledge from them itself. So I think it's already a kudos job that Africa is doing. But the 3 recommendations which I have already given in my paper, which was the first recommendation which I have given, is the awareness session and the education. See, we are teaching our students ADR. We are teaching our students as an ADR for, for only for 6 months or as a semester. Why we are not keeping it as a mandatory subject that people should know about mediation, arbitration, conciliation, and negotiation part? So if we really wanted to want the ADR culture to be adopted by people, we need to put it as a mandatory subject. So this is what is my recommendation for this ADR subject. Thank you very much. And it's lovely hearing my sister Arinze and Nicolina. You have shared your wonderful insights. I have gained a lot of information from your insights. So thank you very much. Thank you very much.
Thank you so much, Dr.
You as well too.
And
I'm very limited bandwidth.
Same here.
That's the reason
Thank
I cannot
you so
give my
much.
face.
Thank you. We learned from
However,
you.
Thank
I
you.
am looking at the lovely
I
faces.
wish we can see. Can we see your lovely face now? Namaste. Namaste. Can we see your lovely face now?
Yes.
Namaste.
In 2 minutes, I would be visible. In 2 minutes, I would be visible.
Okay. Namaste. Okay.
Okay.
Thank you. So
Thank you.
over to Madam Nicolina now. Final remarks.
Okay.
On the way
All
forward.
right. So I want to say and quote Nelson Mandela as well as Kofi Annan. Nelson Mandela said that if you want to make peace with your enemy, you have to work with your enemy. And that is partnership, and that brings dialogue, because every conflict that is resolved through dialogue, what happens? Stronger economy, safer society, and it brings unity and confidence among the people who sit to dialogue. It also leads to fairness and respect for one another, which will lead to economic growth. And I will say that Kofi Annan said, dialogue is the only way to achieve a lasting peace. If we want peace, devoid of violence, conflicts within the region, within Africa, and to help economic growth, we need to make sure that, so the recommendation now will be that, look, let us strengthen our institutions and build ADR system that will be long lasting. It's been done elsewhere. You look at the UNCTRA, you look at the WTO, the establishments that they put in place and the institutions put in place to be able to address conflicts and resolve issues in no time. We can do it. Africa is growing, and ADR is growing in very much. In Ghana, recently we had the court system saying that, look, we're going to have a whole week of ADR system, taking some of the issues on the court and allowing ADR practitioners to handle cases, and it's growing beautifully. So the strengthening of our institution is very important. That is one. Skills development, training, like we have done wonderfully since yesterday. And I want to applaud all the professors and every presenter that has been here. You also want to consider the fact that we want to grow our nation. Consider the investors at the investor confidence as they come in. And so that confidence must be built. And all these things we cannot do and not put it under shell. So there must be awareness creation. People need to have confidence in the ADR system, and the practitioners themselves need to have adequate training. Technology is there to help us, and then we need to network and collaborate. It's important. We're talking to somebody all the way from India. I have learned a lot. Somebody is from Kenya. And from yesterday, this we've been doing to network to make sure that what I don't understand in a case, I could call somebody to help. This is how we can grow. And the last thing I want to say is that we need to bring the younger ones also. We talk about our institutions. Even right from our home, we need to teach people how to sit and dialogue and to make sure that there's fair treatment for all. And this must be instituted. It must be established. When we come to AfCFTA, which is the block we are looking at to grow the African continent, there's a lot of work to be done. Just last week, I was in Egypt on AIO conference where the insurers are gathered, and we're talking about this as the framework is not fully completed, it's not fully appreciated by the framers themselves, and we need to work on it ASAP to make sure that the institutions are strengthened. Thank you very much for the time, and I know that we'll continue with this dialogue, making Africa and the world a better place for all of us.
Thank
wow,
you
that's
so
the
much.
big
Here
Thank you.
Dr.
We see your face. Namaste.
Thank
Namaste.
You. Thank you. So over to Madam Gozi.
Namaste. Thank you.
In a few minutes. Thank you.
So thank you very much for this, the honors and the privilege to be in this platform with so many great faces, women and men. Thank you so much for the contributions from the participants and all. For me, ADR has been, will, and continue to be. So we better adopt, we better adapt to the dynamics that will keep on unfolding with respect to ADR. I wrote some things down. I said harmonized alternative dispute resolution within AfCFTA. And my two sisters have mentioned that there is need for us to have that. From what the professor himself said, is the AfCFTA is more tailored to the states, state-centric. That's the word in his article. But we have to now go beyond that and find a way for us, the commoners, for the market women, the SMEs. They are the ones that do the real business. So how do we bring that harmony so that when, as investors are coming in cross-border, they should be able to predict predictability. Once there is predictability, they will know that once I do investment, even if I'm in Nigeria, I'm doing investment in Ghana, I'm doing investment in East Africa, anywhere. Then also ratification of these conventions, the New York Convention, the Singapore Convention on Mediation, New York Convention is on arbitration, so that there will be recognition and enforcement of our work. So Africa needs to look introspectively. The fact remains, let me just put it, from my own perspective, is as if we kind of underrated the importance or what the benefits of ADR. That is why we are having this discourse now, because we need it to come to life again, that with ADR, not just that relationships are maintained, our economies thrive, because it's only in brotherhood you can actually do business, and an investor would want to do business with you as well. I also wrote on mandatory pre-litigation. Yes, we do it in Nigeria, like in Lagos. There's what we call pre-action protocol. The Lagos High Court is in the rule. So what it means is that before cases will go in for litigation, you kind of sieve it out. You know, there are cases that are tailored more to be handled by mediation. It's like family disputes, anything that has to do with family, workplace. I mentioned earlier about the Central Bank of Nigeria's new policy is yet to be, they are yet to set the mediation panel, that all secured lended transactions must go through mediation panel before you can talk of litigation. That's a very good start. Institutionalizing mediation, arbitration, especially, you know, arbitration, though it has its own merits, but from all the conversations that we've had today, you find out that mediation actually validates. The parties are the ones that are bringing out their own perspective. The mediated settlement is actually coming from the party. So their feelings validated, their contributions validated, and the confidentiality also is at play within the ADR spectrum. So most investors don't even want some of these things, like, not just commercial disputes. When you look at other spaces where alternative dispute resolution works, you'll find out that people sometimes, they don't even want their dispute to be made public. For instance, anything that has to child custody, divorce, so ADR arrest that. Then schools, Deepika mentioned that, and I have already mentioned that as well. Schools, and it has to start early. I read sometime about empathy, I think it's in Denmark, that empathy, children are being taught empathy 6 to 16. So it's a weekly, and it's non-elective, it's compulsory. So when we build from early years the culture of ADR, it helps children with problem-solving skill. It helps them to understand that as humans, conflict is inherent. How do we now, it reduces bullying. And I also read that Denmark is the lowest bullying country. It's there, it's out there in the public, especially within the school framework. So it's something that we have to start very young for our children, so that will be the culture that they will grow with, because they are the generations we are living for. So how do we now, it's supposed to get better. Now we've made the mistake, we did not utilize it well. Now, how do we now embed it in the academic or educational calendar, school calendar, so that they will learn early? I also write mandatory inclusion of ADR in contract, whether private or public, because it's at will. Yes, it's at will, but if it's made mandatory, even in landlord and tenant matters, in anything that first explore mediation. In cases that arbitration is the best win, first explore arbitration. First explore negotiation. That should be the starting point, because mediation is assisted negotiation. So if we can outline all this step by step, just like Professor Olajide said, that pentagon is very, if we include it as a policy that people, and it should cut across all sectors, ADR works perfectly well for all sectors. The only one is when it's purely, there are criminal matters that are not amenable, those ones that you cannot bring to the mediation table. Victim offender mediation for those petty ones can go, but for those ones that are purely criminal, like murder, like rape or gender-based violence, they are non-negotiable with respect to ADR. But you will even see, it will shock you that in practice, people do that. So I will end with the quote of Anthony Guterres. The Secretary General. I say, dialogue is our best and only hope for peace. Let's continue to amplify that. Let's continue to advance that. Thank you very much for this wonderful opportunity of serving AfCOD and ACPSEA.
Thank you
nice
very
to
much,
do this,
ma'am.
and I have to do it. Thank you. Namaste.
Thank you so much. Thank you. So thank you to all the panelists, and thank you, Dr. Jitka. Thank you for giving us the opportunity to see your lovely face. Thank you, Madam Ngozi. Thank you, Madam Nicolina. It has been a wonderful discussion. And I was so much behind time. So there wouldn't be room for so much question. I'll just, Madam Joy has had her hand up, so I'll just take her question briefly. Madam Joy, please straight to the
I think Madam Joy is next on the session, so let her come in, then she can bring her thought as well. Okay, so I'm putting her on the spotlight. So you can introduce Madam Joy, then we'll handle that session. All right, thank you.
All right, thank you so much. So our next session is on, sorry, just 1 minute. So our next session is on traditional African dispute resolution mechanisms and their relevance today. And to take us on this session is Barrister Mrs. Obunyong Okon Mpobre. So I've been calling her Joy. Joy, that's the other name, even if I don't mention it. So Barrister Mrs. Okon is the managing counsel and mediator at ONO Okubre and Co. She's a barrister and solicitor of the Supreme Court of Nigeria, and she has practice experience of over 40 years, and within these 40 years, over 13 years in ADR practice. She's a UK CDR accredited certified mediator and a Ghana AfCOD accredited certified arbitrator. She's also a panel of neutral at the Lagos Multi-Door Courthouse, and she has mediated numerous physical and virtual matters and facilitated settlement agreements across commercial and civil disputes. So ladies and gentlemen, join me to welcome Madam Joy N.O. Okubre. Madam Joy, you have the floor, and then you can open up with whether your question or contribution, and then we'll proceed from there.
Okay, let me give my contribution. It's just a moment before I go into my my presentation on yes. Good afternoon, everyone, and thank you for giving me this opportunity to give this contribution in the last discussion. Yeah, ADR as a driver of economic growth, if I may use Sewese's word for it. A lot have been said, and I've learned so much. It's a learning ground for me, and I want to thank all the presenters in their various perspectives on that subject of ADR as a driver of economic growth. I just want to talk on the, say something on the developmental dividends of ADR. On that developmental dividend, a lot has already been said about the economic, the peace dividend. The mention has also been made about the development dividend. I want to look at the local solutions in terms of SDG. SDG means justice for all by 2030. I had to Google that to get that information. And now we find out that when we talk about development, in practice, development is mostly in the urban centers. In the rural, in the hinterland, the development, the grassroots people, they don't feel development so much when you compare it with the urban areas, and that does not stop disputes from arising. Disputes still arise, and we find out that under this SDG 16 calls for peace, justice, strong institutions, but imported courts don't reach rural Africa. That's the point I want to make. And that's where traditional ADR does. You know, that's what with the area that traditional ADR comes in. You see, over there, we've talked about elders and youth and women settle 70% of rural disputes already. So my suggestion is that if we certify them and we fund them, we'll achieve justice for all without building 1,000 courts or numerous courts at all. So ADR will lead to local capacity and sustainable development. We don't import development, we unlock what Africa already has. That's just what I want to, the bit I want to chip in that development. Now to go to my presentation.
Yes.
Yes. Thank you so much.
I'll be looking at
thank you for that contribution.
Yeah.
Thank you.
you.
So throughout yesterday, we've established the fact that ADR is indeed African dispute resolution. It is not imported. It is indigenous to Africa. And we've continued to make mention of African dispute resolution mechanism, traditional African dispute resolution mechanism. So we'll need you to shed more light in your years of practice, all of that. What are these dispute resolution mechanisms that have been there right from time, from the pre-colonial era until now, that we can adopt and then synchronize with the existing mechanisms?
Thank you very much. Yes. I remember yesterday, I told you about my grandmother's veranda in Nigeria. And today, I want to use that veranda as a window or an opening to see all of Africa. Because what my grandmother did under the mango tree was not only Nigerian, it was African. Two families were fighting. For instance, two families were fighting over land. My grandmother sent for kola. She arranged mats in a circle, and she said, nobody leaves until we find what everyone needs to move forward. Kola, circle, dialogue. Kola, circle, dialogue. That is African ADR. And Nigeria is just one chapter in a very long African book. So I will just be, since I'm from Nigeria, I'll be anchoring the presentation, giving a Nigerian perspective of it, even though I will still mention other African countries. Now, Across Africa, our ancestors built 4 mechanisms for peace. So I'm going to show you that 4 mechanisms, and we'll also see how our sisters and brothers across the continent, how they also, there are various African dispute mechanism, dispute resolution mechanism. 1, in Nigeria, the Oloja settles market disputes with women in a circle. The Umuada, daughters of the land, remove family conflicts sitting around a mat. They just sit on a mat. No head, no tail. Everyone is equal. But Nigeria is not alone. In South Africa, they call it Ndi Daba, which means a matter for discussion where the whole community speaks until consensus is reached. In Kenya, after the 1994 genocide, the Gakaka courts that sat villagers in circles to confess and heal. In Ghana, queen mothers use the chief's palace courtyard as a circle. Lesson for today. The circle kills hierarchy. Even in Zoom mediation in 2026, we still fight power imbalance. Traditional ADR solved these 500 years ago. Cameras on, junior staff speaks first. That's modern circle technology. 2, that's the second mechanism now. 2, restorative justice. And in restorative justice mechanism, they are more concerned with repair, not just punish. My grandmother never asked, who should go to jail? She asked what was broken and how do we repair it? If you destroyed a farm, what happened? If you destroyed a farm, you planted new crops. You apologized to the family. You shared your harvest. Justice was relational. Across Africa, same principle. In Uganda, the Ankoli people practice matso uput, which means drinking the bitter root. Offender, the victim's family drink together after compensation. It means the bitterness is over. In Rwanda, Kakaka focus on apology and community service, not just prison. Relevance today. Nigerian courts have over 400,000 pending cases. Punitive litigation creates losers. Restorative ADR creates solutions. Business don't just want cash, they want suppliers back. Traditional Africa knew this. I attended a restorative justice last week, about 2 weeks ago, and they just gave it a new name. The third mechanism, dispute resolution mechanism, elders and community pressure as enforcement. In Hausa communities, the Magajiya and village elders have moral authority. In Yoruba and Igbo land, what will people say is stronger than any court order. If you break settlement, the community isolates you. No trade, no marriage for your children, 90% compliance without paper. Yes. Historically, community enforcement meant isolation. No trade, no marriage for your children. That method belongs in the past. Today, elders and community fuse demobilization, and reintegration. And then wisdom decides. Community, they use wisdom to decide disputes. And then community enforces through access. In demobilization, elders formally release ex-combatants from group identity at council. In reintegration, the community enforces peace by conditioning access to markets, land, apprenticeships, leadership, no agreement signed, no access restored. Other Africa too. I mean, in other African countries, like in Ghana, the chief and the queen mother's word is law in the community. In many East African pastoralist communities, elders' council decisions are final because reputation is currency. Relevance today. We spend millions enforcing arbitral awards. Traditional ADR teaches us social capital. Modern institutions like Nigerian Bar Association, Institute for Continuing Legal Education and Dispute Resolution now track mediation reputation. Break agreements, lose market trust. Same principle, new language. And then the fourth dispute mechanism in Africa is proverbs, rituals, symbols for healing. Nigeria uses kola nuts. Let there be peace. We pour libation. Ancestors witness this. We use proverbs. Yoruba say, Ajesokpo lo dara ju ijalo, which means cooperation beats conflict. Igbo says, Ife kwalu ife agudabeya, which means when one stands, another stands beside it. Africa white too. The Accra of Ghana use the palaver tree. No dispute settled outside it. The Zulu have mbizo with specific rituals to cool emotions before talking. Relevance today. Commercial mediation rushes to numbers in 5 minutes. Traditional ADR teaches ritual to reset emotions, even on Zoom. 2 minutes of why does this relationship matter is modern cola. It changes outcomes. So what is the relevance of all this for Africa in 2026? 4 urgent reasons, with Nigeria as case study, as I've already mentioned. 1, court congestion and access. In Nigeria, 1 judge to 300,000 people, and it will lead to 10 to 15 years delays. Rulers, Africans can't afford lawyers. Traditional mechanisms are free, local, in local language, available tomorrow. If Nigeria scales this through multi-door courts, like Ghana is doing with customary ADR, with the 40% of court dockets. Trust and legitimacy. Many young Africans see courts as foreign, but they trust queen mothers, umuaha elders, justice in local languages, and cultural respect. And this leads to trust in the rule of law from Port Harcourt to Accra and to Nairobi and other parts of Africa. 3, AfCFTA and cross-border trade. One of the facilitators talked about AfCFTA and cross-border trade. I would just add to what was said in that respect. Africa is trading with Africa. Nigerian supplier versus, that is, if you have a Nigerian, for instance, you have a Nigerian supplier and a Kenyan buyer. Western arbitration fail across cultures, but dialogue, restoration, relationship, that's shared African DNA. After disputes need African solutions, not imported templates. 4, technology and tradition. The future is Circle and Zoom, Cola and e-signature, Elders and ODR. In Uganda, Mato output is being documented digitally for diaspora. In Nigeria, customary courts now take multi-door court referrals. Tradition gives principles. Technology gives scale. Africa resolves matter when we merge both. Let me return to my grandmother. She had no law degree, but she knew conflict is not the enemy, but broken relationships are. She knew justice without healing is just paperwork. She knew no community grows when it cannot resolve conflict. So, my charge today is African-wide. Let's stop treating traditional African ADR as cultural performance. Treat it as intellectual property, our own intellectual property. Research it, document it, train neutrals in it, fund it, from Nigeria's Umuada to Ghana's Queen Mothers, to Kenya's elders. This is African intellectual property. I'll conclude by saying this. Yesterday, during the panel session on the role of women in ADR practice and peace building in Africa, we asked for the mic, the mandates, and the resources for women. Today, I'm expanding it. Give African traditional ADR the mic in law schools. Yes, let it be taught in our law schools, our African traditional dispute mechanism. Give it the mandate in our courts. Give it the resources for research and formalization. Circle and Zoom. Caller and contracts. Dialogue and data. Nigerian leads. Africa follows. And together we resolve smarter. Thank you very much for listening.
Thank you so much, Madam Kubra, for those beautiful insights. It makes me so proud to be an African indeed. Thank you, and thank you so much, ma'am. So would I love to take questions or contributions, but we are really running out of time. So we'll just go ahead to proceed to the closing ceremony. We'll just merge the final session and closing ceremony, everything together, so that we can round up. So Mr. Isaac, over to you.
Okay, thank you so much, Sewese, for the wonderful hosting and moderation. I'd like to thank everyone for participating. Now the closing ceremony has started. So we'll now call upon all speakers, all moderators, and everyone to be here, whilst the chairperson for day 2 will lead us on our lessons and key takeaways from here. So, Professor Chair, please, the platform is yours now. Thank you.
Thank you so much. I really would have loved us to allow people to engage Joy. I hope you've been around since morning, Joy, because we've been referencing you, and I was telling them that all my research for years and so on, your grandmother just, I mean, it was like drinking water for her. And I also said that it's wrong for you to say she's not educated. There are two forms of education. There's Western education and there's traditional education. She had strong local education. If she didn't, she wouldn't be able to do what you thought was easy. I've learned a lot from you. I mean, I've been researching traditional African resolution for several years. And I've written a lot on it. In fact, my last book was on that, Asian practices. As a matter of fact, the New York Bar asked me to come and speak on that, and I turned it into a book. So you have a treasure, and I really would love for you to be at our workshop tomorrow on restorative justice. So if you can, I'll be happy if you send your WhatsApp to me, your number to me, as I can invite you to come and be part of it, and also to share this wealth of wisdom. Because while it is true that I have been on this for several years, what you're able to deliver in 10 minutes, I cannot do that. I cannot do that because you have so much knowledge there. But I want to thank you. And in thanking you, I want to thank all that have been patient. I just checked the number now. We still have 47 people. That shows that I was right, Isaac, that you have a lot of work to do. We are behind you, and we expect to provide us leadership. And you can see it's an international thing. Thank you, my sister, Deep Speaker. I've said severally, I don't know where you have been in the room, I've said severally that the few continents that preserve the traditional methods, including India, Japan, and Africa. So I'm glad that you are here. And I also saw somebody, I think from Egypt or whatever, yesterday. We have in this room a lot of wealth. What has been established in this conference, I think that's the quality of this particular conference, is that we have it. And we should never feel inferior in terms of dispute resolution, because we have our own that works. Absolutely. We have our own that works, whether it's in business or social issues, marriage, like my sister said, and other one. So I think it's very important for us to take away that lesson from this conference, that we must support the incorporation of African values in dispute resolution into Africa as an opportunity. Because our fathers had those disputes, which was the same all over Africa, because they had to do with business. That's why they had it. It was a dispute resolution business. It's not like they use it when somebody kills somebody or whatever. No, it was their dispute resolution system. And throughout Africa, it worked. So if we can take from this, if we can continue to support Isaac and our leaders to push this agenda, that we must, number one, have something on dispute resolution, business dispute resolution, private business dispute resolution in NAFTA, in AfTA, and part of that protocol must include an incorporation of our traditional method of dispute resolution. I think this conference would have achieved a lot. And that's all I have to say. Thank you for your patience, and may God bless each and all of you. Isaac, I think I'll hand over back to you too.
Thank you so much. Now I move on to Professor Emilia. I can see she is back again. Thank you, Prof. Thank you so much for the insight you've shared. Professor Emilia, the floor is yours.
Thank you so very much, colleagues and everybody who's joined us. It's especially actually to Isaac, to Sewise, They've been here all through. Some of us have been going off and on. So thank you very much. A huge thank you to all the speakers. We're very, very grateful. To our keynote speaker, thank you. To Professor Olagunju, thank you so very much. And Dr. Deepak, we're very grateful that Deepika for joining us all the way from India. Thank you. The key thing, I think, is what is the takeaway? And everybody should at least have their own takeaway. I like the fact that Ngozi kept reminding us that we need to start young, and we have opportunity. We all have spheres of influence, wherein I think part of the goal is, if dispute resolution or conflict resolution becomes innate in us, I want to resolve. I would like to resolve. I don't want to, fight and all of that. Then we'll be more imaginative in finding solutions. So that's something that we all can do. We can continue to preach and talk to other people, share information, share knowledge, use our own experience to engage in a meaningful way. And it was funny because I was thinking of, the way we correct, let's just say we want to correct somebody and somebody wants to correct me, for example. And by the time they personalize it, they force me to become defensive. But if they correct objectively and it's not personalized, it's easier for me to even begin to listen, to engage. So I think that we're all growing. We'll continue to learn. We'll continue to engage with our various experiences. So we'll carry through. The last thing I want to say is that for maybe the center might be one of the appropriate forum, because we have to give you assignment as teachers. We give students assignment to begin to pull together researchers, academics that are interested in this field. Let's see whether what the vision that Professor Olagunju has about a bottom-up approach, to see how we can set up a framework, to see how we can make suggestions, so we can build the template for African states for intra-Africa dispute resolution, whether it's the OHODA model, whichever one it is. We can set up the framework and find a way it can be presented to the AfCFTA Secretariat. It can be presented to the AU, but we won't sit and wait for them. We can do it. We've discussed it over 2 days. So maybe let's try and see. So Isaac, I'll leave that with you. I can suggest immediately that the idea came from Professor Olagunju, so let's hold on to him to see whether he's going to lead on this. Let's try and pull that together and publish it and see how this would go. At least that will be our own contribution to that discourse. And we're just saying this is a template that you may want to consider and look at and see how that goes. Otherwise, is to say a massive thank you. I'm very grateful for the opportunity to participate. Thank you so very much. Isaac.
Thank you so much, Prof, for making time out of your busy schedule to chair this conference. We are grateful. And the assignment, yes, we hold on to the assignment, we accept it. And because of that, even before you mention it, I have put evaluation on the chat, where I have put on a session where I asked whether people want to be in a working committee to keep working on the Africa ADR conference. And I think from there, we can take it up from the working committee, we take it up and we'll see how we can get, as you have mentioned, a template or a framework for an intra-African dispute resolution, which will be a great way to start. And we cannot wait for them to do it for us. We have to start. When we are engaging them, then we can have something to show to them. Yes, and also bringing the meeting to a close and learning from what Madam Joy said Cola, Circle, and Dialogue. So now we have Zoom. All of you are on the platform, and we have been able to dialogue within the next for the past 2 days. So over at this point, I'll invite Mina, if you are here with us, to give the vote of thanks or closing comment that you may have from your end as the Secretary General of ACPSEA. Are you with us, Mina? Okay, Mina is not here. Okay, then let's move on. Okay, yes. So the next thing is that, as I mentioned earlier, so the key takeaway that we are also taking from here is that we want to ensure that every third week of June, these activities can be done. So every third week of June, we want to declare it as Africa ADR Week. So Africa ADR Week, where we can continue to have this dialogue. So we are looking at having a physical conference. So not only meeting you online alone, where we can start from maybe a hybrid, then we build on it from there. So gradually we can have. So mark your calendar every third week of June in every year. We can have this platform to do a discussion. So take your time to and please complete the evaluation for us, and also your maybe your acceptance or your volunteering to be part of the committee. We'll start the discussion from there. And also, if there are any suggestions, that anything that you want to bring on board, we will be happy to look at it and also to improve on that. We are all learning every day, and we are committed to that. We want to learn every day. So bring us all the suggestions, all the improvement that we need to do. We'll be able to learn from there. Before we move on, I think Dr. Deepika, your hand is up. Is there anything?
This time we are connected on Zoom, and I'm wishing that next year, June ADR week, we have to be connected physically in, wherever you are conducting this event. So we are hoping for the same.
Yes. Thank you. Okay, thank you. Anything from Sewese? Sewese, where are you? I think I can't see Sewese. Oops. Okay, so let everyone, please, if you are able, put on your videos. Let's take a final pictures.
Sorry, Isaac, I heard my name. I was on a call. I didn't hear what you said, but I just heard you.
Yes. As Secretary General of the Association of Conflict, Peace and Security Experts, I wanted to hear your closing comments and also to thank all the people that came on board.
Well, I was on a call, but I guess you've already done that, or you still want me to do it?
I was still waiting for you.
Please, let's say we say finish and then because I'm still on the call when I heard my name.
So we say is connecting back. Okay.
So you go on with your announcement. I'll get back to you in the next 2 minutes.
No problem. Okay. If we are not out of here. Okay, please put on your videos. Let's take a picture. Yes, we want to see all the people that were behind the screens. Yes. Thank you. I hope the 2 days have been beneficial to all of us. I have learned so much, and I believe you have also learned something. Let's keep talking. It is only through this discussion that we can all build a better society for ourselves. Okay, so I'm taking the pictures. Okay, I can still see Sewese So we say, are you here? Okay, so there were people who were also asking for certificate, whether we were going to give them certificate. If you want a certificate during the evaluation form, when you are filling, you can request for a certificate and you will be obliged to issue you a certificate. That one, because we need to design, they to attract a small fee, but the conference and everything is being done for free. So take note of that for those who may request for certificates. All right, so I was waiting for Sewese to be back so that we can close, but unfortunately, Sewese is not here. Okay, then let me invite Lawyer Kezia, do the vote of thanks for us.
Hello, everyone. Good evening, good morning, good afternoon from wherever you are. On behalf of the President of AfCCoD and ACPSEA, I want to thank everyone from all the chairpersons, from the one keynote speaker, Foluke, Professor Emilia, Professor Olajide, every panelist, every moderator, especially so we say you've done so well to host us as the biggest country on our network. We are grateful. We are grateful for every panelist. We are grateful for every moderator. We are grateful for every participant who spent their time and data. We know that your times are very, very expensive because of the nature of the work that we all do. But you came to support us to make sure that the annual ADR week, the annual African ADR week has been very successful. So on this note, I join hands with the president and all the executive members and say that every third week of June, we shall be meeting somewhere in Africa to continue our conversation. And we hope that by the time we come to this meeting next year, we will all be here to celebrate the many, many successes and the push forwards that we have done. Thank you so much. And may God bless us all. Amen.
Amen.
Thank you so much. Thank you. Thank you, Barrister Kezia. Thank you. Bye-bye.
Bye.
Bye.
Thank
Guys, see you next year.
Thank you, everybody.
Yes, indeed.
Bye. Take care. Good night.
Bye, everyone.
See you next year.
Yes, indeed. Thank you. Thank you so much.
Thank you. Bye. See you next year.
Bye-bye. See you next year.
Thank you, Mr. Isaac.
Yes, we want to do a closing prayer before we go. Don't run away. Closing prayer before we go. So we are praying. Almighty Father, we thank you for bringing all these exceptional leaders into our midst and bringing them on board for us to observe the African ADR Conference. We thank you for what you have done for us. We pray that continue to inspire us and give us wisdom that we may impact the next generation that will come, so that this discussion that we are having, they will not come and have it again, but they will come and build upon what we have done, and through that, they glory be unto your name. Amen.
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 All right, so on behalf of the organizers, we want to say that thank you, and the conference has ended. Thank you for joining us. Long live Africa.
Thank you, Mr. President. Thank you for the organization.
Thank you, Mama.
So,
Mrs. Mbabre, thank you for delivering so beautifully well. Like today, you spoke like more than a lecturer.